statutory application.
Majority whip. Be brief.
Yes, Mr. Speaker, I'm being brief. But let us be brief. But let us settle the matters on the law. The application before the court is a statutory application. There is no injunction application before the court. It is an application of statutory seeking the parliament, the court should prevent parliament from performing its constitutional rights. And that application will be heard at a definitive date. But in the meantime, the Supreme Court says Parliament must continue to perform its constitutional rights. So that matter, the minority leader shouldn't go there. It is settled. It is right. It is settled that he knows. We are not dealing with might. We, the minority, will not shut our mouth. You can follow due process.
In the court regarding the propriety of the processes relating to the removal of the Chief Justice, the previous Chief Justice. And because there is litigation regarding the processes leading to the removal of the previous Chief Justice, this Parliament should not consider a nomination brought to this Parliament, a nomination which the Speaker has accepted and which he has referred to a committee for the committee to process. And I once again draw your attention to the fact that the same Supreme Court has said that in matters that are primarily the responsibility of Parliament, once Parliament starts dealing with those matters, no one anywhere can stop Parliament from dealing with of the Chief Justice is properly before this House. It has been referred to the committee, and the committee will. I urge him to appear before the committee as a member. You can ask all your questions.
The law binds us all, and the law is the law, is the law. Those who said, and the law is the law, did not complete the sentence. The law is the law, is the law. That is the sentence. As the law binds us all, and the law is the law, is the law. Those who said, and the law is the law, did not complete the sentence. The law is the law, is the law. That is the sentence.
We are not dealing with might. That bad thing will not happen. It will not happen. You must follow due process. Follow the law. Do the right thing. We, the minority, will not shut our mouth. You can follow due process.
You are saying that there is litigation in the court regarding the propriety of the processes relating to the removal of the Chief Justice, the previous Chief Justice. And because there is litigation regarding the processes leading to the removal of the previous Chief Justice, this Parliament should not consider a nomination brought to this Parliament, a nomination which the Speaker has accepted and which he has referred to a committee for the committee to process. And I, once again, draw your attention to the fact that the same Supreme Court has said that in matters that are primarily the responsibility of Parliament, once Parliament starts dealing with those matters, no one anywhere can stop Parliament from dealing with those matters until Parliament has completed the process of dealing with that matter. The nomination of the Chief Justice is properly before this House. It has been referred to the committee, and the committee will sit on Monday. I urge him to appear before the committee as a member. You can ask all your questions.
The law binds us all, and the law is the law, is the law. Those who said, and the law is the law, did not complete the sentence. The law is the law, is the law.
Right. So it's exciting to be here this morning, and you have been on right from 7 a.m. Doing the honors to, of course, God and country, right on the Good Morning Ghana. And here we are, as you see in the back screen, the veteran of His Lordship, Justice Paul Baffoe-Bonnie, which is set to begin right on the spot 11 a.m. this morning. And this will be Metro TV's extensive coverage of the entire veteran. If you have followed the proceedings, you would realize that as of last week, the Minority Leader, Honorable Afenyo Markins, had made an appeal for the veteran to be held for some other things to go through. But the Speaker of Parliament, and those are the videos we've been playing for you, mentioned that the law is the law and the law. And so this morning, myself, Kwesi Afri, I'm here with my dear colleague, and we are bringing you the, the extensive coverage of the veteran proceedings of His Lordship Justice Paul Baffoe-Bonnie. We are anticipating and expecting a number of questions to be mounted or to be put to him this morning, and we are quite sure, as expressed by a number of people, that he will and be able to answer all of the questions that are put to him. And so when he is approved, we would have not an acting Chief Justice, but an effective Chief Justice. And this follows the, did I say Austin?
Removal.
Necessary. The removal of Chief Justice Gertrude Tokonu. There are still appeals that she's making to some courts, ECOWAS courts, for example. And so, Annie, what are we to expect this morning?
So, firstly, let's deal with, just in case there's someone watching, and I mean, we've vetted appointees. Sometimes we sit in. It looks like this has been one of the most controversial vetting ever in the country. That is because of the incident that preceded this appointment, and so it has actually raised concerns. So should you not be well informed about what has led to this, why Chief Justice Gertrude Tokonu was removed? I'll just read a brief for you so that we are all on the same page. Ghana's President John Dramani Mahama fired the country's Chief Justice Gertrude Tokonu following the recommendation by an inquiry. Now, so she has been suspended since April after complaints were lodged against her in petitions by 3 individuals. Now, a president-appointed commission then found that grounds of stated misdemeanor, and that is what's stated in the law, has been established and recommended her removal from the office. Mahama's office said on Monday. So Ms. Tokonu has dismissed the allegations as unfounded and politically motivated. The presidency said Mahama was required to act in accordance with the committee's recommendations, but critics also fear that it sets a worrying precedent and undermines judicial independence. In its investigation, the panel reviewed 10,000 pages of evidence of 13 witnesses on behalf of the petitioner, Daniel Ofori. Now, the Chief Justice also testified and called 12 other witnesses, including experts. The 2 other petitions have not been concluded. Ms. Tokonu has been removed as in fact, it's Mrs., as a judge of the Supreme Court following the committee's findings. The inquiry found evidence of unlawful expenditure of public funds linked to her private travel, and her spouse and daughter were reportedly paid allowances using public funds during a private trip with her husband to Tanzania in 2023 and another to the US with her daughter. Now, she also faced allegations of interference in appointments by sidestepping procedures for appointing Supreme Court judges and abusing powers in the transfer of a judiciary employee. Mrs. Tokonu, Ghana's 3rd female Chief Justice, was nominated in 2023 by former President Nana Akufo-Addo, and she is the first sitting Chief Justice to be investigated and dismissed. Chief Justice in Ghana enjoys security of tenure, meaning they can only be removed from office on few grounds, which included incompetence and misbehavior, but that has to be stated in law or established. However, Ms. Tokonu, legal representatives have dismissed the basis for her removal. In April, the opposition New Patriotic Party condemned her suspension, describing it as a political witch hunt and an attempt to undermine judicial independence. Multiple lawsuits challenging the removal process were unsuccessful, and she had previously survived a removal request under Akufo-Addo, who found a petition to have several deficiencies. She also has been accused of bias in some of her rulings by the government's party or ruling party, which was then in opposition. And a former Deputy Attorney General for Afetua has also criticized the decision to remove the Chief Justice, saying that it is a dangerous precedent. The AFP News also agency reported that the petition that I read showed no proper grounds to warrant her removal. This was a quote from Deputy Attorney General Afetua at the time. So it goes on and on. It's an article. The final word says that the Chief Justice still has the opportunity to challenge her removal in court, although she may not receive a favorable outcome. And I deliberately wrote this because this is none of the local reports. This was actually put together by BBC, and I think they have captured the chronology of what happened in Ghana pretty well.
I mean, regarding the removal of the Chief Justice, the appointment of an acting, and then currently.
Yes.
Well, so go ahead.
Go ahead. So just in case, I'm actually done because it's very long. It's a long read, but I think I've read the salient parts for you to have an idea of exactly what has been going on, just in case you're still at loss of why the current new Chief Justice appointment and a vetting process to proceed to follow, which is today, and that's why we're here. So, Kwesi.
And that's quite insightful. I mean, lots of people probably have looked at the reasons. There are divergent opinions, those of the New Patriotic Party, those of the National Democratic Congress, those who are naturally neutral, quote and unquote, expressing their legal opinion on what has transpired. And I love the fact that you mentioned, or the article you read gives us a chronology of some of the events and the reasons for which the president terminated the appointment, even though it is largely classified or expected to be a secured term. A secure term. So there's been mention of
security of tenure.
Security of term. So there's been mention of sidestepping of procedures, travels, the legality of them, and so on and so forth. Let's see. Metro TV has put together some slides regarding these. Let's see the first one, what we are referring to. So if the producer has video walls that we have. So Article 146, that's the removal of justices of superior courts and chairmen of regional tribunals. That's Article 146. So we are going to go through this briefly for you. It says, that's one. A justice of the superior court or chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on grounds of inability to perform the functions of his office arising from infirmity or body of mind. So this one we are referring to whether the person is sick and inactive to be able to perform his or her official duties. Now, the president shall, in each case, act in accordance with the recommendations of the committee. And that's what exactly has transpired currently. The President, His Excellency John Dramani Mahama, has been acting in accordance with the documents, or with the Article 146. And that's what we are discussing here this morning. So pretty shortly, we'll be going to Parliament. My colleague Dominic is in Parliament. He's been gathering data, who is arriving, who is coming in for the veteran, who is coming to support the acting Chief Justice, Justice Paul Baffoe-Bonnie, who from the minority side will be sitting on the committee, from the majority side will be sitting on the veteran or the appointments committee, and all of the questions that are expected. He will be giving us snapshots of what's happening in there. And of course, if he gets the opportunity to interview people as well, he will be able to interview the people that he comes across. On social media, you can join our feed on Metro TV News on all social media platforms. So make sure that you are following us bit by bit, up to speed on everything that's happening regarding the veteran. All is coming to you live, of course, from our studios here at Rage in Accra, from Parliament, and live on social media. On Metro TV online as well, we are bringing you up to speed bit by bit, also the details of the stories as they unfold. What is the Chief Justice answering to? What question is he answering to? What exactly is he talking about? We'll be bringing you up to speed on all of these platforms. So stay with us. Metro TV online, Metro Socials, so on YouTube, on Metro TV Facebook, on Instagram, on Twitter, X, and on TikTok. We are bringing you up to speed on all of these places. And of course, we are live on DSTV channel 277 and live on Multi TV 2. Remember also that we have some experts, in fact, legal practitioners from both the MPP and NDC, and those who are not affiliated to any political party, who will be speaking to us and sharing their insights with us also pretty shortly.
I was pleading with Bright to give us one of the very controversial videos of the former Chief Justice when she was being vetted, and that was about your Ghanaianness or documents that you're allowed to use to declare your nationality. And I think one of the issues had to do with was it a Ghana card or something like that, to use birth certificates to be used as your evidence of Ghanaian, and she responded to it. I was just trying to put together the read. If Bright can, find that video for us, we'll be very excited. It has been one of the most controversial issues when it comes to our proving of our nationality. And I think this debate has lasted so long. I don't know if we have now come to a conclusion of what you can still use as a document of proof of your nationality.
Yes.
I'm not sure if we've brought it to rest, but just a quick
I think it's a dynamic conversation, an organic conversation. We'll get to the point where no other card, apart from the Ghana card, you see the current CEO is working very hard of the National Identification Authority to make sure that if there were lapses, those lapses will be sealed. And eventually, so you remember he's speaking about the synergy with the banks. Even though the banks are using it already, the few lapses that he thinks exist, how we'll be able to close those gaps. The synergy with the DVLA, for example, we are talking about the cancellation of toll booths and so on and so forth. How we can use the Ghana card to align with the banks, align with DVLA, and then when you are supposed to use a toll booth, you would not have to now go through that long queue, go through traffic, and eventually still come and pay. Right. Laura, so good morning. Thank you very much for joining us. If you can hear us.
Good morning. I can very well hear you.
Right. So thank you very much for joining in. This morning we are expecting Justice Paul Baffoe-Bonnie to be vetted in Parliament, and so our cameras are there. Everybody is watching Metro TV. We are happy to have you this morning. What do you make of it? It's a question I don't like to ask, but beginning the conversation, let me ask you, for you as a lawyer, looking at the precedents, the removal, I'm tempted to use the word ousting, but that would be very wrong because it wasn't an ousting, it was a process which was duly followed by His Excellency, the President John Dramani Mahama. But for want of better words, let's leave that for you. As a lawyer, with everything that has happened, I will still ask the question that I refuse to ask. What do you make of it?
Thank you very much. I make up on this process as we testing our constitution and seeing what works for us and what doesn't work. Okay, so seeing the role of Parliament strongly when it comes to the appointment process of the Chief Justice, even though I have had an earlier divergent opposition, a divergent view to the process. So this is a process that somewhat appears to undermine the judiciary, because if the appointment of the head of the judicial arm is done by the president, then of course the president is a human being who will not appoint someone who opposed to his views. You look around and see who is aligned. This is where the president appoints. You see that there is a stronger, stronger arm, a neutral arm that verifies or that views.
Hello, Council.
The president, yes.
Council, can you hear me? So if you can hear me, I want you to please reposition yourself. We're having kind of a break in your transmission so that we're able to hear you well. There is a point you are making that I would want you to clarify, that you say that the process undermines the establishment of the judiciary. If that's what you said, to probably clarify it. So if you have positioned yourself very well now, you can now proceed.
But is it better now?
Yes, very well, very well.
So the point I'm making is that I'm making a general statement that if you look at the appointment process of the Chief Justice, where the president nominates in consultation with the Council of States and the prior approval by Parliament. And I'm saying that if you take Parliament by itself, Parliament appoints its own head by way of electing the Speaker. And this is, our case is not special. In other countries, the president also appoints. But you will find that in those countries, the House operates the bicameral parliament, where they have the Senate, and then the House. Let's say you take the U.S., the House of Representatives. And then the Senate, which is less political, is the one that is given the power to approve or disapprove the president nomination.
Right.
It means that it is not two political elements that are appointing. That is the point I'm making.
Right.
So this is not in reference to whatever that has happened or not.
Right.
I am a watcher and also a worker for a public administration, so I wouldn't want to, double in that. But the point is that a CJ can be removed per the constitution we have. Yes, there's security of tenure for public officers, across the board, but you can be removed when you act, beyond. And then you have read. I followed you when you were reading, the grounds upon which
Yes,
you
yes,
can be taken
yes,
off.
yes,
So
yes.
that should not be new.
But
If the
Council,
process is not being adhered to, then of course the courts are open for you to test that. Yes.
Council, what would you want? I mean, as a legal practitioner and being in the judicial system of the country, will you require that we have a system which takes off the president as the person appointing the Chief Justice of the country?
Yes, if you look at the appointment regime of the country generally, the president appears to have the first hand in it. And so if that is what we are to go by, then of course the cry that we should convert our Council of State to the upper house, so that the Council of State, which will be less political, will have the power to approve the nomination of the president. That is the system that is being recommended.
But currently it is done in consultation with the Council of State, not solely by the president. I am asking that, will you want the president off the entire process at all?
Yes, so that was what I was coming to. But even in respect of what we have is not too strong a Council of State that advises or tends to be consulted by a more powerful overriding president. So you can never have, anything stronger there. But I'm saying that if it's converted to a legislative chamber, the upper house, the upper chamber, then you would full force as the lower house. Then we can have some impact there. But on the extreme proposal is where the judiciary itself, the judiciary itself will have a system to for the justices of the Supreme Court to appoint one of their own. But that will also mean that subsequent or below the appointment of Supreme Court judges, there are also processes that will take away the president's hand, so that you will have the judiciary itself producing. But that's the ideal state. But I'm saying that if that will be a exception, then we can even have the system we have, but we will form it by creating or converting the Council of State into the upper chamber, where such a body, looking at the members of the Council of State as we have as to be continued, then we can say that with that force, now they don't have any teeth at all to bite, but giving the teeth and then subjecting such an appointment by the president to such a neutral body or a far objective body, then you can have that.
Let me ask you, I mean, we would come to issues of precedence, we would come to issues of the premise for which Gertrude was removed, and we would come to the substantive matter itself. But the vetting is happening this morning. You are a lawyer. If you were in and part of the vetting committee, what would be your most important question you would ask?
Thank you very much. Yes, and I'm sure that we have quite competent members of the appointment committee who ask questions that will seek to reform the judiciary. We have backlog of cases. Cases take too long to be decided. Some way, somewhat, there is some lowering of the image and trust of the judiciary. Some have suggested that sometimes they produce political decisions and all that, and some have suggested that it's been more unanimous decisions which do not bring out dissenting views that can help develop the law in the opposite sense. So my question would have centered on the efficiency of the judicial service, automation, and fast tracking of cases. I've listened to a call by the president of the Ghana Journalists Association asking for a special court to be created to deal with galamsey. It's all because we are not getting the speed we want. So how can we, some have suggested that we should even give timelines for disposal of cases, which may be quite unrealistic, but cases are just taking too slow, and you have no idea how far-reaching that has on our, our investment climate and all. Very, very important that justice denied, justice delayed is justice denied. It must be fast-tracked. Let's employ all processes, especially technology, to fast-track our cases.
Do you think that the acting Chief Justice, if he goes through the vetting, he gets approved and becomes the substantive Chief Justice, would face some problems regarding precedent? For example, when he's traveling and he's required to travel with a spouse, he will be guided or he would come under pressure as to what to do based on the evidence adduced in the removal of Justice Gertrude Tokono.
Yes, thank you. Yes, President is to serve us, to guide us in our forward march. So, of course, if you have a president that suggests that you shouldn't, you are not entitled to certain things, or you are forbidden from conducting yourself in a certain way, so that should be even positive for him. Maybe first the law was not in application, so you wouldn't feel it that way. But this one, you have seen it in action, and that even brought you into being. So he will be fortunate. He will be fortunate to walk the path that constitutionally is permissible, that the path that will, endear the judiciary once again to the people of Ghana and give us the best of justice that we all want.
Right. So let me leave it here. But I'm sure you are not gone yet. I don't know, and if you want to ask him any question before we let go of him.
Hello?
Lawyer, can you hear me?
Yes, I can hear you.
Okay, great. I'm taking you to the August House where we heard the minority screaming follow due process. Now, the majority chief whip, Roxanne Defemeko, has indicated that whatever case is in court, Parliament can still proceed, and then later we can hear the case in court. I'm not, anticipating the results of what will happen in court, but what is the consequences should this process go on before the court hearing?
Okay, thank you very much. So your question comes under the legal principle we call the sub judice principle, which, tries to make Parliament restrain itself from matters that are pending before the court. And remember here that it's a restraint rule. It's Parliament that is saying that for me or for us as an assembly, we have to respect the other branches of government, or some have suggested the branches of the state or the arms of the state. Okay, so the judiciary has authority to decide on disputes. And so if there's a matter pending before it, then Parliament, out of respect for the judiciary, will do that. But the question arises as to where you have a matter that you have to act against constitutionally, against your respect for the other, where you have to now test your own independence first, because you can have a case where it can be abused. That can be abused.
Yeah.
That can be abused. So because you have a matter, I don't want you to take on the matter and arise to court and say that out of your respect for the court, I hold your hands. That may be a difficulty. That is why this principle, you can't find it in an express form in our laws, either in the Constitution or the Standing Orders of Parliament, but it's a rule that is applied within the Commonwealth, that the Parliament will restrain itself from dealing with matters pending before the court. But like I said, there is a balance, there is a delicate balance that has to be struck, and that power is given to the Speaker, that the Speaker will look at the matter in question and decide that is it a matter that we will want to respect or restrain ourselves. Remember, it's not a rule of thumb, but it's a self-restraint rule that we want to respect the judicial for this matter. But in all cases, one needs to assert himself first and foremost before he can assert another. So if you think that that will undermine your own independence, then you don't do that. Okay, so and I'm sure that is the position that the speaker has taken. So
we don't see
that should be allowed.
So we don't see any attempts of Parliament to abuse its power allocated to it by the Constitution.
No, but like I said, this is not a constitutional provision. This is a self-restraint measure that is adopted by parliaments within the Commonwealth.
Oh.
Okay, but they always have to analyze the matter in question, okay, as to whether this one is a matter that we think that we will restrain ourselves or not. That is exclusively left to Parliament.
But
so,
so the case in court does not directly affect the vetting or otherwise. However, the person to be vetted is a beneficiary or a victim of circumstances of the same case.
Yes, that does not matter. So that is why I'm saying that the question was raised and the speaker rightly decided. Okay, but as we know, when Parliament has acted and then you have a basis to challenge that, you are free to challenge that. I don't know why today that we should be concentrating on how Parliament can effectively assess the suitability or otherwise of the nominee. We are having this discussion because we've gone past that. If Parliament or anybody is taking a step, when the step is matured, it can be challenged. Okay, so if anybody thinks that, and that's the beauty of the constitutional level we have reached now.
Yeah.
See, matters are tested. Even laws Parliament passes, they are tested. Even now, even the ones that have not even seen accent can be challenged, and then the speaker is saying you wait for it to be, enacted fully before you challenge. So there's no problem about it. It's about you are acting within your constitutional powers or not. So Parliament has the power to exercise. Let Parliament exercise that power. If there's any disagreement, the courts are open.
I was staying away from Justice Okonu's situation, but there are people who have criticized her of going on and on and on and still fighting this case. You have also mentioned the case of testing of the laws, which is a good thing. That's what the Constitution allows us to do. As a practicing lawyer, do you see this as something good she's doing? Because I think since it has not happened before, it's something that we want to look at the space, set precedents, and then it becomes a learning curve for us as a country. No?
Thank you. But when it comes to litigation or asserting your rights, you don't listen to what anybody says, especially if it's not an encouragement. Okay. It's a personal decision. That is why the courts are there. If you file frivolous case, they will still tell you. So there shouldn't be any limitation as to what anybody will do. But as you said, it's even an opportunity for us to delve more into our constitutional provisions, explain them so well, so that we are duly guided, in future. You have made a point that, it's an opportunity to develop our constitutional laws. So be it. But as to what you may want to exercise, some clients appear before you and they want to say, oh, this matter, I want some resolution, but I don't want to go to court. It's the person's sole choice to make. So if somebody wants to go as 100 times as permitted and the court will allow it, it's not the business of anyone to complain. You pay money to go to court. So if you are paying money to file cases that will not help, it's a choice.
Well, without preempting, just before you go, without preempting what may come up at the vetting committee, what are the areas you think will be appropriate for us to hear from the incoming Chief Justice? If questions are asked, you will wish that he addresses such matters to bring clarity to some of the ambiguity within the legal system.
Yes, thank you very much. I think this exercise is an exercise for Parliament to assess the suitability or otherwise of the persons who nominated. It's not a forum for him to espouse, opinions on some matters that are unclear in the public's mind. That is, the forum is the courts. Okay.
Yeah.
So, and I'm sure that such questions may come up, but the nominee or the chair may exercise some discretion in that regard. But yes, it's all about, for me as a citizen of Ghana.
But the just removed Chief Justice had the opportunity to express a few opinions on the use of birth certificates as a Ghanaian, being a Ghanaian document.
Yes, but that matter had been decided by the court.
Okay.
Okay. In other jurisdictions too, you can ask that are not already in dispute. So you don't use this opportunity to seek personal view of the matters that are already in court or will go to court. But if there is on a general matter, if you ask the nominee maybe his view on the abolition of death penalty in respect of murder, for example.
Yeah.
It's a matter that is concluded as in practice, and you want to have his view, fine. But if you, let's say, LGBTQ or what matters, and there are some reflections in the court, then it will not be fair for to be asked such questions. But what I'm saying, all that we want is development. Development in the case of the justice sector is where you have speedy, efficient disposal of cases. And that should be the overriding point. If you have any other matter that warrants judicial determination, it's not parliamentary vetting.
Well, Auntie Do.
Right.
We'll leave it here. I'm grateful for your time. Because do you have any more?
I think we are done for now.
Okay.
We are okay for now.
I'm sure we'll engage you again. We're now going into the vetting, so we're going to all listen to it, and then we'll get back to you for some more analysis on what will be said. Thank you.
But whilst we prepare to wait for the Chief Justice or the acting Chief Justice who is going to be vetted this morning, our colleagues Dominic and Theo are there. And I mentioned that they are going to bring us up to speed with the details of whatever happens at the vetting room today. That's Appointments Committee's room today. So we want to see how the security is getting the place set up. People, so we early on showed you visuals of people, how they are getting in the hallway and so on and so forth. I don't know if we are ready. We'll be able to show you how the setup and how the security arrangement is so far currently. The hallway leading to the venue or the room where the vetting itself would take place. Everybody is earnestly waiting for, I guess, the arrival of the acting Chief Justice, or His Lordship Justice Paul Baffoe-Bonnie, who is set to take after Chief Justice Gertrude Tokonu after her removal. And so, if we have time later on, we'll be bringing you a bit of a background of who Justice Paul Baffoe-Bonnie is, what cases he's noted for, and as we speak, we are told that he is the senior most member of the bar for the Supreme Court judges, and so it's in right positioning for him to lead the entire judiciary or the Supreme Court. Everybody would listen to him. And the worry, however, is about what his tenure will be, how long he would serve before he goes on retirement for a new process, this same process to begin all over again, and how the entire country is going to take it.
For reasons best known to me, I I get restrained a lot talking about the appointment of Justice Tokonu at that time. I wouldn't want to go so much into it, but it has been still a very controversial situation because he, Baffoe-Bonnie, is the senior most person. And so it was expected that, at the justices level, when you're senior most, it's almost like automatic. The lawyers would explain better that once you're senior most, you should be considered as the the Supreme Court judge. I don't know what decision goes into maybe bypassing one or two to get another person who is almost not at the level where the seniors are. Because there were more about 1, 2, 3. And there's been some controversial debates surrounding
political and partisan debates.
Exactly.
You're running away from.
Not necessarily. I'm actually running away from it, quote unquote, for personal reasons, not necessarily for legal, either legal or political reasons, but for personal reasons. And so I think that has also been a driving point of debate since Mrs. Tokonu's appointment. I guess she understands what I'm talking about. It has really been the debate all through till now. A lot of the judges, I'm sure, might think that, okay, if she has been removed and a new person must go, then it has to be the senior most. And I guess that's what it is. It is what it is. But Dominic is standing by.
Yes, so I see Dominic standing by from Parliament. Dominic will be telling us what's been happening so far, if he's gotten the opportunity to speak to anybody already. Dominic, if you can hear us, how are you? What's happening in Parliament currently?
Well, Kwesi, yes, I can hear you loud and clear. And also, good afternoon to our viewers. Yes, good morning to our viewers.
We are still in the morning, Dominic.
Is heated up, The vetting of the acting Chief Justice is going on. It's ongoing exactly 11 a.m. Yes, exactly 11 a.m., sorry. The vetting process will start. As it stands now, security at the entrance is beefed up. And protocol is in place. We can see the security apparatus is also coming in to support the process so far. Here at the entrance of the committee room where the vetting process is taking place or going on, we are still here seeking to speak to one or two people. We've seen Honorable Jerry Ahmed here. We are live. We would like to discuss with him. Honorable, we are live on Metro News. Talk to us briefly. What are your expectations so far with the vetting process that is here to take place?
I honestly do not think that I have any extraordinary expectations. I think it's a vetting process. And it has to be. And we are going to do our part, and that's it.
Right, but you are here. As you believe that the minority leader is also here, because way back in Parliament, that was somewhere around Friday, the debate was laid in Parliament, and then the minority projected that the vetting process will not come on. But today, we've seen you here. You are a leader in Parliament. We are hoping that is your leader also joining the vetting process today.
We are still here. Watch and see.
Right. So that was Jerry Ahmed, a member of Parliament for Wejak-Bawe, who is saying that they have no expectations so far, but then they are here. I mean, way back in Parliament, somehow around Friday, it was very contentious in Parliament, where the debate was heated when the business statement was laid on the floor of Parliament by the majority leader, Mahama Yariga, who said that Monday 11 a.m. the vetting process will go on because they've gone through all the constitutional process, and then they deem fit to have the vetting process of the acting Chief Justice, Baffoe-Bonnie, today. But then we can see the minority is here. I was asking whether the leader is also here seeking to have a feel of what is going to happen, that is today. But it seems that that is the answer he could give us, that they are waiting to see what will happen, but they have no expectations. So earlier on what I said, Kwesi, that security is beefed up right from the entrance. Access to the committee room where the vetting process will take place. It's not an easy task for you to just enter. Security is making sure that things are done properly and things are done right. We can see that the Immigration Service apparatus are here. The National Security Coordination, some of them are also here. We've seen lawyers from the Ghana Bar Associations who are also here. We've seen the police entourage. The leadership of the police administration is also here. We see the Fire Service Administration who is also here. I mean, all the security apparatuses, I must say, are here seeking to also have a feel of how the vetting process will go. If you can see, people are right there, and then that is where the entry point is. You have to be checked in before you can enter. But then as at now, the acting Chief Justice, His Lordship Baffoe-Bonnie, is not in position now. But the committee chair and the committee members are also in place, all seated, waiting for the process to go on. We've seen the former Ghana Bar Association president, who is also here, I mean, seeking to also have a feel of what will go on and how the process will take. So we've been here at the entrance of where the committee will be seated, and then the vetting will take place. And then we are waiting to have some member of parliament, even from the majority side and also the minority side, as we earlier spoke to Jerry Ahmed, who is a leader in parliament, to find out how things will go. We are also hoping to see the majority side here so that we can also have a discussion with them as to how things are going so far. But as you can see, this is how parliament looks like. This is how it is going to be, and this is what we are here for.
Very much, Dominic. Dominic coming in there from Parliament.
Because it's over to you in the studio.
Yes, Dominic, we can hear you live and colored.
Baffoe-Bonnie entered already because they gave us 11.
No, he hasn't. He hasn't. If he had, I'm sure Dominic would have told us about it. But Dominic, it's already 27 minutes past
right, so
11.
No, he hasn't. He hasn't as at now.
Mm-hmm. All right, so thank you very much there, Dominic.
So he hasn't as at now. I mean,
we'll come back to you. We'll come back to you, Dominic. Thank you very much. And Dominic is coming in straight from Parliament. We are hoping that His Lordship Justice Paul Baffoe-Bonnie will be in the vetting room very soon. I'm sure that he may be around waiting for signal to come in when the committee is set. By 11, I'm sure he was around. I am sure. I'm only conjecturing. But when he comes in, we'll see him, we'll have him, and then the questions will begin. We'll transmit that live to you. You want to stay here at Metro TV. We can now come back to the studio, Annie.
Yeah. So I can actually let you also know that Marietta Briopon, who is a legal aid to the president, has also arrived in Parliament.
Oh, wow.
I'm sure
wow.
they are all going to observe how the process will go. But we have a guest who's joined us.
Exactly.
So let's go on.
Should I say morning or afternoon? It's actually mid-morning. Cancel. Let me allow you to do the introduction first. And,
no, do it. You do it.
So
I like the way you go, Council.
he had attempted going for a parliamentary seat. Yeah. Am I allowed to ask you about it? Central Town. Yes.
The question is, am I allowed?
Am I allowed? I mean, will you? But what happened? We can mobilize ourselves and put our monies together. So we can follow you.
It's too early. It's too early.
Too early?
Yes, it's too early. We've just come to government 10 or 11 months, and we have to concentrate on the job that we have to do so that at the end of the day, our people and Ghanaians will see that we have delivered on the mandate. Yes, I think that is the most difficult thing we have to do now and make sure that it is done well so that it does not become like all politicians are the same, that the MPP is the same as the NDC. We need to differentiate that the two political parties, we have different philosophy, ideology, and the way we do things. So when we get there, then when the people say, yes, this is the time for you to come, we'll definitely go.
Let me ask you a very basic question. People believe that you are doing very well. The government, the current government is doing very well. We can mention a number of sectors. Just this morning, I was following a report on the agri sector. I've been following reports on the macro sector. I've been following reports on industrialization. I've been following different reports. Do you think you are doing well as a lawyer in the legal sector as well?
Oh, yes. I think that the government with the new
with the removal of Gertrude Tokonu and the appointment of a new one, do you think you are doing well?
Oh, yes. I think that things are being reset. The reset agenda is moving on. Things are getting into shape. I think there are teething problems and issues which will be met head on, and at the end of the day, where the target and the mandate is to make every stakeholder happy, to make sure that the populace are happy that, yes, we had voted, we've gone all the way to queue and voted for the NDC, and we are reaping the benefits of good governance. I think that's what people want to see. So once you go in and you see issues, maybe, because you were not involved, you were an observer, you had bits and pieces of information as to some of the challenges, things that were happening. Now, when you get in, you realize that the story is different, it is more deeper, it was only the tip of the iceberg. But once you've been given the job, you have to fix it. And I think government is actually on course, doing well. The only minus maybe I may see is that the party, most of the grassroots and others are not too happy.
The party, grassroots are not happy?
Yes. It's
the NDC foot soldiers are not happy?
Oh, some of them, yes. We should not mind sweat. In that their expectation is so high, and the expectation has to be managed because they feel that it is time for tit for tat. It's a payback time. It's a payback time. But some of the things that maybe we have been expecting, it may not come immediately. Especially when it comes to jobs. I know now that it's come to recruiting to the services and the rest, they will feel that, oh, look, they did it for their own people. It is our time to do it. But at the end of the day, we are all Ghanaians. Yes, in as much as we need to get our people in there, it's about the populace. I always ask simple questions when people are asking. I ask that, do you have a mouth? Do you have stomach? Everybody has stomach. Everybody eats. So we can't say that because your parents or your people did A, B, C, D to me, they denied me what I should eat. It is now my time, and I will deny you, that I will starve you. No, I don't think that it's human. It is just and it is fair. Yes, so I'm sure that I don't believe in people who say, oh, you are impartial. There's nothing like impartiality. To me, you just must be objective and you must be fair. That is all. Yeah. Because everybody has biases. Yeah. We know where the chiefs' allegiances are. So,
all the chiefs in the country,
we know where the allegiances are. Everybody, people
whether they are MPP or NDC.
Where I sit here today, right? Everybody knows I'm an NDC man.
What do you think their allegiances are on Galamsey?
Yeah. The Galamsey.
When you raise issues of Galamsey, where do you think the allegiance of the chiefs are?
Of who?
The chiefs.
The chiefs? But the chiefs are in the middle of it, the controversy.
Where's their allegiance? Is it to the Galamseyers or to government?
Most of them, their allegiances are to the Galamseyers because they
most
see
of the chiefs in the country.
But who owns the land? Who is the custodian of the land? We have family lands. We have two lands. And can any family sit down and say that we own this land whilst the Ebusuapeni is under the control and influence of the Omanhene, and Omanhene will say that it is the the Baffoe-Bonnie, he owns his a family land, so within my traditional area, he can do anything. No. Look, sometimes we pretend that we do not know the people, but the problem where we are getting to on Galamsey is becoming like mafia. It's becoming like, and
a cabal.
A cabal. And the simple thing they would do, as Asantehene said, is that, if you come, we won't vote for you. So anytime they want to hold you ransom because of vote. For me, if this would be the issue, right, the Galamsey, nobody is saying that don't mind. Our forefathers, our parents have mind. Mind responsibly. You see, and what hurts me personally is that if you are mining and the money they get, the Galamseyers, it goes into their individual pockets. Does it come to us? Now it has to take the state, the government, to spend money to correct what you are doing. When the money, the benefit comes to you individually, it never comes to us. We say, we have benefited, so we now use part of the proceeds to go and correct some of the measures.
But when it comes to Galamsey, it is that understanding that even the Galamseyers don't get, that once you benefit something from the land, government must benefit from it, except that you have to do it legally. They think that you can just go into the ground, dig the money, and get away with it. That's it.
It's education because...
Yes, and they will tell you that we don't have a job, so that's what we have to do.
No.
So this point you're making is very important.
Yes, if we don't have a job, I have siblings there who don't have a job, they finish university, then they should have been going into armed robbery. They should have been going to prostitution to say that we don't have a job. So this is the only option.
Yes.
And there's a proverb in my language that the mere fact that you are hungry doesn't mean you should eat with two hands.
Yeah.
While I'm eating with two hands, that shows that I'm hungry. Whether you are hungry or not, you still eat with only one hand. So this Galamsey issue, look, I am even shocked that these Galamseyers, who knows very well that what they are doing is illegal, have the effrontery and temerity to threaten the state.
Actually attack the state.
No, they have threatened and have attacked the state. And we want to go slowly on them. I think that this issue, when we don't nip it in the bud, we will be engulfed.
Is it fair to politicize it?
To politicize it?
The Galamsey issue.
No. You see, that they know that the easiest solution for them to try is to politicize it. Because when they put the politicians, their head together, they pit them together, then it becomes politics. And when it comes to issue of politics, religion, people stop to think.
I'm happy about the statement.
Right?
I'm very happy about
it. Yes. Because
very, very
once
happy.
it is, I'm pigeonholed. Let me give you an example. Everywhere they go, they say, even some people don't even know my name. They only say, sir, NDC lawyer, no. NDC lawyer, no. That's how they pigeonhole me. And I accept it. Right?
Yes.
I have very good friends within the MPP. If today I decide I'm going to...
In fact, you deal with cases associated with the NPP.
Even MPP, the cases associated, anybody needs my services, whether you belong to MPP or NDC. You need my services, and it is genuine, and I know you have a good case. I won't allow anybody to triumph on your right just because to say by my association I should keep quiet for you to be jailed. Or no, it won't happen. Because at the end of the day, when I go to heaven, my belief as a Christian is I'll go to heaven one day and I'm accountable. So will I go and say because I belong to NDC as a party, I saw somebody doing something wrong and I kept quiet? No, it should not be like that. It will not. So,
all right.
Yeah, I think that the Galamsey issue, sometimes, I think government has said that they have enough options that we have to exhaust. But I think the way it is going, which I heard the president yesterday said, communities who attack the states will be dealt with. I think we are getting to, I'm beginning to have some inclination to the state of emergency thing that they were, pockets of the places to deal with this issue. Nobody's saying that it should be the whole enclaves that they mine. People are doing responsible
So that when you
mining.
declare a state of emergency, you have a stronger legal framework to work within.
I'm thinking that so that you can actually, they diagnose the problem and make sure that they deal with it.
Lawyer, we will do Galamsey definitely later, but say a word or two. Obviously, it's starting the three leaders, Deputy Speaker, Minority Leader, and then also Majority Chief Whip.
Deputy
Majority Chief Whip, all in one shot. But a word or two before we go, let's take a listen to them. What do you make of what we have? The procedures have been questioned by the minority. They said they will not be a part of it. Or maybe we should just listen, just in case the minority may stage a walkout.
Yes.
I'm sure they
Yes,
have
yes,
something.
yes. I'm anticipating something. Let's go and listen.
Nominated to be the CJ. I mean, it's a big thing. I'm proud that I have people would get.
With a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving. A country of peace, where government shall rest on the will of the people and the love for the common good. Bless the effort of those who struggle to make this vision a living reality. Inspire and strengthen our people that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Amen. Honourable members, may I use the opportunity to welcome all of us to the vetting of my Lord, the Chief Justice to be. Honourable members, following the nomination of the Chief Justice, His Excellency, the President of the Republic of Ghana, by a letter dated 17th October 2025, communicated same to Parliament. Honourable members, this was duly referred to the appointment committee to conduct the vetting and report to the House. In view of that, this meeting has been organized. Honourable members, the purpose clearly is to vet His Lordship Justice Baffoe-Bonnie as the Chief Justice of Ghana. Honourable members, he has been vetted and approved by this House as Justice of the Supreme Court of Ghana. He is now being elevated to a leadership level as the Chief Justice. We are therefore here to have him vetted. Honourable members, once again, you are all welcome. Honourable members, as the tradition demands, we shall proceed to call on the clerk to have the Chief Justice sworn in.
I hereby proceed to lead the nominee to take the oath.
Chairman, for the record.
I believe these proceedings must be orderly. When you have an issue, the practice is that you catch the eye of the speaker, and in this case, the eye of the chairman. You don't have a right to ask anybody to stop proceedings for you to say whatever you want to say. Honorable members, the idea is, why should I refer to him as a Chief Justice but not Chief Justice nominee? Chief Justice nominee, you are welcome.
Let me see.
Honorable Habib, let me hear you.
Chairman, thank you.
I hope it's not different from what I said, Chief Justice nominee.
Close to what you said. Initially, you said the clerk shall swear in the Chief Justice. And this is Parliament, and for the record of Parliament, that will be captured. So if you are correcting it, then direct that. Your earlier statement should be expunged from the record.
Unfortunately, you don't have a right to tell me what I should do. Once the correction has been made, may we proceed to administer the oath. Clerk of the committee.
I hereby proceed.
I, Paul Baffoe-Bonnie,
Swear by the Almighty God.
Swear by the Almighty God.
That the evidence I shall give before this committee.
That the evidence I shall give before this committee.
Touching the matter in issue.
Touching the matter in issue.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Thank you.
Thank you very much. Honourable members, procedurally, I will ask the members of the committee to introduce themselves. It's going to be self-introduction, starting from my left. Honourable members,
Eji Baffoe-Bonnie, the Honourable Member of Parliament for the good people of Menchia South, and Vice Chairman, the Subsidiary Legislations Committee.
Yes.
Thank you, Mr. Chair. My name is Hassan Tampuli. I'm the Member of Parliament for the good and virtuous people of Gushegu in the Northern Region, and then Deputy Ranking for Constitutional and Legal Affairs Committee of Parliament. Thank you, Mr. Speaker.
Thank you, Mr. Chairman. I'm Honorable Anthony Mie, Member of Parliament for Odotobri in the Ashanti region. I also serve as the Vice Chairman for the Committee on Judiciary. Thank you.
Thank you, Mr. Chairman. My name is Kwame Enyimedwenchi, Member of Parliament for Santiachem Central and a ranking member for Constitutional Legal.
Joseph Rimpon, MP Nkoko, Chairman of the Judicial Committee. Thank you.
Kwame Appiah-Kodia, Member of Parliament for Mfantiakwa North in the Eastern Region. Subject member. Petitions. Petitions and Judiciary, sir. I'm here as a subject matter member. Thank you.
Petitions Committee.
Petitions, and I'm a member of the Petitions and Judiciary, but I'm here in the name of the Judiciary.
The rules are clear in Standing Order 1217. Strictly subject matter committee.
I'm here on the ticket of the
and
Judiciary.
then leadership of the subject matter committee. So you are either a chairman, vice chairman, ranking, or deputy ranking of the committee. Honourable members, let me use the opportunity to clarify Standing Order 217. We do not want any confusion. If you know you are not a ranking member, deputy ranking, chairman, and vice chairman of the subject matter committee, please perpetually remain silent.
Thank you very much. Patrick Boamo, Kankwe Central, a member of the committee.
Jerry Ahmed Shaib, MP for Wejagbawe, leadership.
Alhaji Habib Idrisu, Member of Parliament for Tolon, First Deputy Minority Whip, Member of the committee.
No, don't pray. Salman Reji, Minority Whip.
Yes, now on my right.
Thank you very much, Chair. My name is Bid Anwatasmo Zieden. I am the MP for Laura and ranking for Judiciary, subject matter representative.
Al Hassan Umar, MP for Zabzugu in the Northern Region, a member of the Appointment Committee.
Thank you, Chairman. My name is Shaibu Mahama, MP for Daboya Mankargo, Chairman for Constitutional and Legal Affairs Committee of Parliament, and a member of the committee.
Thank you, Chairman. MP for Adan leadership. Thank you.
Ladi Ayayamba is my name, MP for Pusiga, ranking for Chieftaincy and Culture, and a member of the Appointments Committee.
Chairman, thank you. CJ nominee, you're welcome. My name is Roxanne Nelson Dapamako, MP for the good people of Southern, member.
My name is Mahama Ayariga, Member of Parliament, Boku Central Constituency, leadership.
Thank you. My name is Kweku Ricketts Hagen, Member of Parliament for Cape Coast South and the Vice Chairman of the committee. That's the Appointment Committee. Thank you.
Afenyo Makin, MP for Efutu and ranking for the committee.
Bernard Ahiafo, Chairman of the Appointment Committee. People also call me the Kingmaker. So, honourable members, commencement. Yes, I see you pulling the microphone. Do you have an issue?
Chairman, with respect, thank you for the opportunity, and I shall proceed with my opening remarks, which remarks I make for and on behalf of the minority caucus of this committee.
Honorable Minority Leader and the ranking member of the committee, I shall accord you every respect and the time to raise your issue. My only hope and prayer is that whatever issue that we are going to raise must be raised within the rules that governs this committee as well as the entire Parliament. The floor is now yours.
Chairman, thank you very much. I shall proceed my remarks with a quote from Shakespeare's Macbeth, Act 1, Scene 7. First, as I'm his kinsman and his subject, strong both against the deed, and as his host, who should against his murderer shut the door, and not bear the knife myself. Besides, this Duncan has borne his faculty so meek, has been so clear in his great office, and his virtues will plead like angels, trumpet-tongued against the deep damnation of his taking off, and pity like a naked newborn baby, striding the blasts of heaven's cherubim, housed upon the silent couriers of the air, shall blow the horrid deed in every eye. Tears shall drown the wind. I have no spare to prick the size of my intent, but only vaulting ambition, which overleaps itself and falls on the other. Chairman, this morning, on behalf of the caucus, we hear with a heavy heart, but an unshakable resolve to defend the Constitution of Ghana, protect judicial independence, and uphold the rule of law. We gather to vet a disputed nominee for office of Chief Justice of Ghana. This should be a moment of national pride and institutional renewal.
I have an issue.
Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control.
Honorable Minority Leader. Honorable Minority Leader, just hold it a second. Yes, Honorable Ayariga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we gather here. Order 122 and 123. I want you to focus on those two orders. 123 talks about content of speeches, whereas 122 provides the grounds on which debate can be interrupted. So I come under order 122. But my objection is founded on content of speeches. I've heard the ranking member of the committee refer to, I believe, the nominee as a disputed nominee to the post of Chief Justice. 123 says, a member shall not raise any question. 123(5). A member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. I recall that just a couple of days ago, I think Thursday, the same member brought a motion to the House trying to stop this committee from sitting to vet the nominee. The matter was exhaustively debated, and you, Mr. Speaker, gave a ruling. Subsequently, the Speaker himself, because you sat as a Deputy Speaker, the Speaker himself came and recounted the motion and also gave a ruling. So this issue about the propriety or otherwise of whatever happened has been raised on the floor, debated extensively, and a ruling given. Apart from that, Order 1237 says that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Judicature of this country in Parliament except by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody, and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object. So I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
Yes, Honorable Habib, there is an issue raised.
Yes, that's what I'm...
And I must give the floor first to the person who raised the issue in relation to which objection is being taken to respond. Yes, Honorable Minority Leader and the ranking member of the committee. This is the issue raised to part of the submission that we have started raising. What is your response to it?
Chairman, first of all, the majority leader is clearly acting in bad faith, seeking to obstruct the rather peaceful processes we have started, and as it were, try to use his numbers to intimidate. Let me ask, the rule he relied on has to do with debate on the floor of the House. There are dark clouds indeed in this country where freedom of speech by mere operation of a supermajority, you cannot even as a member of parliament make your comment. I am not moving a motion. I am not debating. Please, Chairman, the rule he relied upon. Is it this situation where people move from here and there to create confusion and create their own jurisprudence must come to an end, with respect. Interruption of debate. That is, if you go to page 70 or the 122, the title there, the subtitle, interruption of debate. Debate may be interrupted by a point of order. And then he says that I am debating. Who is debating here? Mr. Chairman, if the majority leader has anything to say in opposition to my opening remarks, he has a right bona fide as a leader of government business and as a leader of the House to also state his submission. I have seen him with his written submission, be it for his opening remarks or see that to you as a chair of the committee, to read it for answered. But this process where, as it were, try to use it to deny you, don't say this. So every line that I read, he will censor it and say, you use this word. Mr. Chairman, we are not going to make any progress with that. Again, the 1, 2, 3 that he relies upon. He says that the conduct of the Speaker, the Chief Justice, members and Justice of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. With the greatest respect. Have I raised any issue that is situated within the context of 123(7) to warrant this so-called objection? Chairman.
Honorable members, can we have some order?
Chairman.
Honorable members, can we have some order and listen to the minority leader in silence?
Chairman, we are here to discharge a civic duty and responsibility. We are political actors who have our political views on matters of national interest. The matters giving rise to the nomination is purely political, and every Ghanaian adult knows this. Your side raised it as a political issue during the campaign. You are going to remove Justice Tokonu as Chief Justice, and that has happened. If in my statement I contextualize to say that disputed nominee, it is our view we hold as a minority caucus. Right, express it. We have to express it. And that is why I added by saying that this should be a moment of national pride and institutional renewal. Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control. Can't I have these bona fides also that have to be obstructed by the majority leader when you have every unfettered right to raise your issues? Chairman, humbly, please control proceedings. Please take charge. Let our respected leader of government business understand that after speaking, after making my comment known on behalf of the minority, he can seek your leave to also make his opening remarks. By the way, by way of conclusion, this is not the first time a leader in the minority is having this opportunity to make opening remarks. It predates me. From J.H. Mensah's era, he and J.H. Owusu Achampong, all the way to Alban Gbagbin, MP for Naudole Kalio, and minority leader as he then was. The videos are there. Hansard is there. Honorable Gbagbin had unfettered opportunity to make his political statement on behalf of the minority, and they were not stopped on point of order. It got to Chairman Sabonsu, it got to Harun Edrusu, and recently, my own respected colleague, Dr. Kasiel Atufosen. The records are there. Let's not create a certain impression as if all it is you are majority, so we cannot even say a word. We must have our rights. These are far right. We will state them, and you would also have the opportunity to state them for the record. Please, let us have some more
Honorable
decency.
Minority Leader, your point is made.
Yeah,
yes, you have listened to the response.
Right, Honorable.
Honorable members, it's not every issue that will necessarily call for the chair making a ruling. But honorable members, I indicated as a preliminary issue that let us all operate within the rules. Honorable members, may I add that we need to also observe the principle of brevity. Yes, what do you have to say?
Chairman, if you read rule 1233, where in the opinion of the Speaker, the words of a member used in a speech, and it doesn't matter whether the speech is at plenary or at committee, a speech is a speech in Parliament. So where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. So, Speaker, when we came into this chamber, this committee meeting room, and you started, you referred to the nominee as Chief Justice. When you refer to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also an acting Chief Justice. And an acting Chief Justice is a Chief Justice. Now, he has referred to the nominee as a disputed nominee. Disputed nominee. Disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination. If there is a dispute about some other action. So you have no right to look him in the face here before this committee and refer to him as a disputed nominee and expect me to sit here and not respond. So, Mr. Chairman, pursuant to our own rules, he has to withdraw and apologize to him for referring to him as a disputed nominee when he is not a disputed nominee.
Chairman, let me.
Honourable members.
Chairman, he has had two opportunities to make a point. Let me respond to
Honourable members, Honourable Minority Leader, listen to what I will have to say.
Okay.
Please proceed and raise your issue. Avoid the use of disputed Chief Justice. Once I do not have a right to refer to him as a Chief Justice, but Chief Justice nominee, let us all observe that rule and refer to him as such.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
I object again. I object again.
On the 22nd April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
Hold on. Honourable members, I think at this particular point, I must place on record that I have admonished that we should all operate within the ambit of the law. Honourable Minority Leader, be guided by Order 103D, and then let's make progress. And Order 103D, if I may read, to serve as a guide to all of us. It states that a motion shall relate to a definite issue and not revive the consideration of a matter which had been considered in the same meeting unless new matters have arisen. Honourable members, by necessary implication, whether a motion or not, The principles of res judicata will not permit us that a matter that has been raised on the floor resolve to its finality would be permitted to be raised at a committee meeting. So, Honorable Minority Leader, refrain from anything that is relating to sub judice rules and let's make progress, with all due respect. Because Speaker has dealt with this matter, I have also personally dealt partly with this particular matter, with all due respect.
Chairman, the facts speak for themselves. On April 22nd, 2025, Chief Justice Gertrude Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship, Gabriel Scott Puama, to trial the Chief Justice amounted to a travesty of justice.
Chairman.
The removal
our rules are clearly offended.
In the language
our rules are
of
clearly
judicial
offended.
accountability.
Because the rules I just read clearly offend that.
But
the rules clearly are offended. Chairman, the rules say that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Chairman, let me respond to him.
You see, I cannot go and be giving you the opportunity when the person who is speaking is in the process of responding to the issue.
It doesn't fit in the rules.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman.
Honourable members, order. Honourable Oman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to.
Yes, before I address, I've made an observation. General knows how much I respect him. He knows how much I respect him. And this must be reciprocated by him. When the respected learned Mahama Yariga, leader of government business, was raising his objection, I remained quiet to listen to him because I know that decency requires that we listen to each other in silence. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the majority leader. Chairman, it is his contention. It is his contention that my reference to the committee's work amount to attacking the conduct of its chair. With the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view that the committee's work resulting in the removal of her ladyship, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend Order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament except a substantive motion. Now, the distinction must be made. Respected Ayarga, please, bear with me. I've listened to you. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal conduct that one would consider as misbehavior or stated misbehavior. I am not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't attack him. The caucus is talking about, please, Honorable Ayarga, let me finish. You were allowed to make your point.
Yes, but Honorable Minority Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed. Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? When you have the right to say your own, you are the leader of the House, you have unfettered right to rebut. That is the debate we even have on the floor. When there's a debate, you take note. When you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. We
Honorable Minority Leader, kindly conclude for me.
The work of even
Please
the
conclude for me. Conclude for me.
I beg you, leader.
Conclude.
We all agreed, Chairman.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority leader.
Travesty of justice is now.
I have listened to the minority leader. Honorable members, we should be guided by the principles that if there is an issue on the floor of Parliament which has got to do with another who may not have the opportunity to respond to it, such a thing should not be made on the floor. Now, though Justice Gabriel Puama is here in person, at no point will he have the opportunity of responding to any issue raised about him. none of the committee members will have the opportunity here and then to make comment. Therefore, for you jumping into a conclusion to say that their report amount to a travesty of justice without any of them having the opportunity to respond offends our rules. I will consequently order that anything in relating to the committee and Justice Puama should be expunged from our record. That is my ruling.
Chairman,
Kindly proceed.
Chairman, let me protest the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That's it. I will proceed. Yeah. We hold a view that the removal of Her Ladyship Justice Gertrude Araba Isaba Tokonu was cloaked in some opaque circumstances unacceptable to the jurisprudence of our country.
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable Minority Leader, you know the rudiment of the game. If you don't want interruptions, let's go by the rules. Other than that, the chairman will be compelled to listen to the person and make ruling.
This one is friendly. Opaque. It's friendly. Opaque.
Yes, Majority Leader.
Mr. Chairman, please. Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. Freedom of speech. But before this Committee of Parliament, the rules are clear. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this Parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did he say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, a travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honourable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I would order that same be expunged from the record as if it doesn't exist. Honorable Minority Leader, proceed.
Chairman, with respect, Chairman, with respect, he raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised the objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honorable Minority Leader, kindly proceed.
It is our contention that the process leading to the removal of Her Ladyship Justice Araba Isaba Tokonu was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman,
we
I
continue.
I hope, Chairman,
to say.
I hope, Chairman, that persistently violating the rules of this House is a breach of privilege. You know that. Persistently
if that
violating the rules of this House.
Chairman,
Honorable Minority Leader.
He's made a point. Let me make a point with respect to you.
Honorable
Chairman,
Minority Leader, if you can hear me out,
yes,
maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is. So I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect.
Honorable
Mr.
Tampuli.
Chairman, thank you very much.
In this house, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted? or it should not be permitted. So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is re-litigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And it is the view of the minority. And I think that it should be allowed to land. Then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker. Thank you, Mr. Speaker.
Honorable Tampoli, if you want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampoli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order
Yes.
5.1, subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2, in any case not provided for in these orders, Mr. Speaker shall decide on a procedural question. And finally, 3, in exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing,
yes,
it may not be provided for expressly.
No, but
so
what you are saying,
what you are doing
yes,
amounts to being guided by Order
the
5.
rules, yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution, under
So you
Article
agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say the Parliament. So, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to land. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable
comments.
Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule again, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24, B and D. Mr. Speaker, with your permission, I read Order 24, B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24 D have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote consensus on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and he correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip. It is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the rights of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your rights would mark the end of somebody's right. Thank you.
Chairman. And keep to the rules because I will object to anything that violates the rules. But when we do this, it's not okay.
Mr. Chairman,
Minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions, our own Supreme Court, the High Court, and the ECOWAS Court of Justice, now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain pending,
Mr. Chairman,
while the very question of whether a vacancy exists remains
Mr. Chairman, I object.
There is a nomination to replace.
I object.
Can have the floor. Honorable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from running commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this House, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings, and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are a friend of marking. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afroyo Makin, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away once I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
I have his.
If it gives you the opportunity, because he is on the floor, tell him. When he said I should hear Tampuli, I heard Tampuli. Should I hear another play? Should I hear another play?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodonpre, what do you have to say on the issue raised by the majority
Speaker,
leader, Honorable Mahama Yarga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised at some of the issues being raised by the majority leader, saying that, show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show me the rules that tells us that every Friday you should be standing behind the dispatch box and presenting petition. There are no rules on that. But it's part of our practice. A majority leader will respect you. You know this. So don't keep referencing that, saying that, show us the rules, show us the rules. It's not just about the rules. It is also about our practice. Now, the very rule you referred to, 103, when you said it could be applied mutatis mutandi, I think, Majority Leader, you are wrong. The rules were made with specific functionality, and the 103 you quoted is on admissibility of motion. No, it's motion. And it's giving us conditions for admissibility of motion. So when you read the heading, so you are interpreting the rule to suit your understanding. A while ago, Tampuri just referenced Order 5 and says that interpretation will be done by the Speaker. Allow the Speaker to lead the process. Allow the Speaker, the Chair, to lead the process. All of us are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong impression, and the public is watching. You will not even allow the minority leader to speak. And you are marking every sentence, and we are here saying that that is normal. Why don't you take your note? When he's done, then you can present your version of the truth.
His law teacher started marking his sentences long ago. I'm not the first person to mark his sentences. His law lecturers marked his sentences for years.
Anytime it appears to me, I'll conclude, because you are pushing me to conclude, I'll conclude. But interestingly, the majority leader catches your eye every time. It is surprising that he always catches your eye. When we also draw your attention, let us also catch your eye. We also have something to say. Parliament is not just about the majority leader. For heaven's sake, I'm representing the good people of Insama Dredji. And when I have a view and I catch your eye, you must allow me to express him. I want to tell the majority leader, anytime he obstructs the minority leader, we will also obstruct him. No? Let him make his point. If it is the case that your strategy is that you are going to obstruct him, we will also obstruct you. And you won't make your point. But the begging question is, to what end? Are we going to conclude this vetting? What are we telling Ghanaians as representatives of the people? Speaker, I think you should rule on this matter. The majority leader should put down his points.
Honorable,
can I finish? For heaven's sake, can I finish? The respected majority leader I saw him taking copious notes. He should write down his points. And regardless of the fact that he's a majority, he's a member of parliament like anybody else. Let him write down his points. When the minority leader is done, then he can come in. Then we can make progress. This whole strategy of any sentence...
I would have been asking questions, but sometimes when I ask questions, they take it that I'm being sarcastic. I will give the floor to Honorable Roxanne Dafamako.
Chairman, thank you for the opportunity. Chairman, given where we are, I seek your guidance on this matter. And here it is. Within the terms of Order 103, Rule D, Rule E, and F, the minority leader led a team of its members. They filed a motion. The terms of the motion, Mr. Chairman, reads as follows: that this Honorable House, having regard to Articles 110, Clause 1, 125 to 127, 144, Clause 1, and 146 of the 1992 Constitution and Standing Orders 57, Rules 1 to 3, Order 93.
Is that the motion Speaker rule on?
Yes. For the records, I'm reading the terms of the motion they filed. Yes. Order 103, Rule F, Order 216, and Order 217 of our standing orders resolves to suspend forthwith all further proceedings, both at the Appointments Committee and our plenary, on the nomination of Justice Paul Baffoe-Bonnie as Chief Justice until all pending suits and applications directly bearing on the removal of a leadership Justice Gertrude Araba Isaba Tokonu, Saki Tokonu, including ECOWAS Court, suit number ECW/CCJ/APP/32/25 on provisional measures, multiple Supreme Court proceedings, and High Court applications are finally determined or withdrawn, and that in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination, and that the Attorney General and Minister for Justice be summoned pursuant to Article 103 of the Constitution to appear before this House or before such committee as the House may designate, to provide a comprehensive briefing on the status of all pending litigation relating to the removal of a leadership Justice Gertrude Araba Isaba Saki Tokonu, including but not limited to A, the identity, jurisdiction, and procedural status of all such proceedings; B, any provisional measures, interim orders, or conservatory orders sought or granted; C, the relief sought in each proceeding and their potential implications for the office of Chief Justice; D, Ghana's international obligations under regional treaties relevant to the ECOWAS Court proceedings; E, the government's assessment of potential legal and constitutional implications of proceeding with the appointment of a successor Chief Justice while such litigation remains pending; and F, any other matters relevant to Parliament's informed exercise of its constitutional functions under Article 1141. Applicants of the motion.
Well, hold on. Let me hear you, Honorable Habib. What are you objecting to?
Chairman, Parliament and parliamentary proceedings and practices. A member is not to address the House. What Honorable Roxanne is doing is addressing us whatever he's reading, Mr. Chairman.
Honorable,
Mr. Chairman, but
you are completely out of order.
To us, Mr. Speaker.
You are completely out of order.
So, Chairman, no, he should stop.
It is only when a supplementary question is being asked.
A motion that the Speaker has ruled.
Would you listen to me,
reading the
Honorable
motion
Habib?
on the floor.
Would you listen to me? It is only when a supplementary question is being asked that you don't address the House. So you are completely out of order. Honorable Minority Leader, may I have your response?
Chairman, I'm not done.
Okay, hold on. Then conclude.
Yes.
Conclude.
No, I'm not done.
Then conclude.
So, Mr. Chairman, these were the terms of the motion the Minority Leader and his group filed. In the course of considering admitting this motion, Speaker determined that the motion cannot be admitted. Now, the Minority Leader, as ranking member of this committee, is using a backdoor approach. He has rehashed the terms of this motion contained in a speech, and he seeks to read that speech before this committee.
Honorable Member, conclude.
It cannot be done.
You've made your point. Yes, Minority Leader, let me hear you.
Chairman, with respect, thank you for the opportunity. Let me first respond to the issue raised by the respected Majority Leader, which issue he anchored on Order 103F. For the avoidance of doubt, I would repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with emotion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. 2, that the substantive matters have not been dealt with.
Honorable Minority
Leader. Let me
Leader.
finish.
With all
Chairman,
due respect.
You allowed
Hold on.
the Minority Leader. I'm
I'm
responding
not
to his
asking
objection.
the Minority Leader to raise an issue. Order.
I am responding
Order.
to. I'm responding.
Honorable
Let me
Minority
respond.
Leader.
Let me respond.
Honorable Minority
Let me
Leader,
respond
hold
to
it.
him.
Honorable Minority Leader, hold it. May your microphone be off, Minority Leader.
Chairman, just a second. Bear with
Minority
me.
Leader,
Chairman.
let your microphone be off. Hear
Chairman.
me out.
Very well. I will hear
Yes,
you.
I'm
and then
supposed
continue my
to
argument.
play the fair game here.
If you make your point, we respond.
Honorable Minority Leader,
What is wrong?
please, please,
I
just
don't have to
observe
respond.
me.
The Chairman spoke.
Hear
for
what I
almost
will
20
want to
minutes.
say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said
been,
that. You've said that. You've said that.
Why?
You've said that. You said that. You said that the nominee swiftly empaneled a court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
I have the floor. You've not called.
Chairman, the rules.
You have not called him. Chairman, you see, Chairman, he puts on the rules.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear, Chairman. The rules. So when you just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement, if we consider this motion, you shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it.
Okay,
Not
no
for
problem.
him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read, in extenso, your motion. So anything that relates to your motion would not be entertained before this particular committee. Because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response. The majority leader has raised his issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the majority chief whip. The majority chief whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that. Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the majority chief whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the majority leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esaba Tokonu has rights, far rights. And what becomes of her when eventually the court determines that all her reliefs are upheld, and then what becomes of us?
Yes.
What
Honorable Majority Leader. Honorable Majority Leader.
You are hearing him?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished
him or me
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So, minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them someday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, Chairman, what the majority leader is doing, is not fair. He raises his issues, you don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours. Because
Honorable members, order.
When you are talking,
order.
When you are talking, you don't talk about the
on
time.
this note, we will break for cocoa. So it's time for cocoa break.
Secretary.
Yes, boss.
Patron Fakot document in brother.
Pacho Medeba. Boss, Pacho. Oh, sorry, boss. Father, boss, na a drop a name, I'm saying.
It's Unti Tontina 74 Mishanka.
Wow.
Over air for general well-being.
Sir.
You're very good. And money, man, you have it, man. Copy Binato.
Any a crujio.
Copy Binato. Ghana for say munim say medumani say make you try aji amanfo sa ena me hia edro a ebetwitwa aji me afi yare ahodro bebre na metumi agina me na so aji amanfo asabe num 1374 mixture ema me apomodin e support me immune system na ema me asomdwe
edro yi nyama apemfo abata won ma o manufu ene nkoda won nimfie duwe FDA aji dwede nkrato yato.
Uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, Mommy.
I'm the second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Troll from Kaswa. Why wouldn't he be late? Or be late? Of course.
Star 712 hash, star 712 hash. Yeah, you go be the luckiest. Go be from to be luckiest. From not the block, she be luckiest. Yeah, you go be luckiest. No matter why you're luckiest. Everybody go be the luckiest.
That's Kwame!
Send your God up boom. If you're poor, what's that? So would the coming of the Son of Man be.
Hey.
Is that his car?
Ha! Even now, your shadow the way designer.
I use my own mouth to reject him. Oh, this is my mouth. Look at that.
Kwame, my son. Now, tell me the truth. How did this all happen?
Oh, Mommy, simple direction. Mr. Good Luck no check me way.
Yeah,
man.
Easy cry. Or dial star 712 hash.
The devil is a liar.
He picked his ticket and entered his lucky 5-digit number.
I'm his birthday.
Oh, how romantic.
And he followed the prompt. Yes. And then boom, confirmation test.
One quick, pick 5 numbers for me, okay? I'm feeling like 7.
Dial star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompt and let destiny handle the
You see how they love you now?
Yo, do you have family permission? Before December, may release a motivational album. Patapa, my super.
This promotion is regulated by the NLA on the Caritas platform.
West Africa's soil yields global treasures. Cocoa, cashew, shea, and cotton. They power industries across the world. Yet for our region, the greatest value still slips away, exported raw, taking with it jobs, industries, and the promise of shared prosperity. The real question is no longer what we produce, but who captures the final reward. True prosperity lies in the value we add right here at home. That's why the 4th edition of the EBIT President's Roundtable will gather the architects of Africa's prosperity and Africa's transformation to answer one defining question. How do we finance the journey from the farm to the port? Join Dr. George Ejikum Donko and some leading experts as EBIT leads a high-level dialogue to unlock financing, empower local industries, and turn West Africa's raw potential into industrial power. Be part of the conversation redefining our economic future. Live on Metro TV, DSTV Channel 277, and EBIT platforms on November 24, 2025 at 11 a.m. EBIT President's Roundtable 2025. From the farm to the court, financing the value chains of West Africa's cash crops. My name is Anita Erskine, and it will be an honor to host you.
Are you a headmaster, headmistress, parent, teacher, or an educator looking for high-quality textbooks for preschool, primary, and junior high school students? Look no further than Advocate Publishing Company. Advocate Publishing Company is a leading publisher of educational materials in Ghana that publishes very engaging, interactive, and comprehensive textbooks that meet the needs of students, teachers, and parents. Our textbooks are thoroughly published to make learning fun and easy. They are also designed to stimulate critical thinking, problem solving, and creativity in students. Make Advocate Publishing your preferred choice for all your educational needs. Explore our range of textbooks and educational resources. Visit us at the old GNTC yard near Kingsway, Accra. You can contact us on 0503 786 776 or 02408 06354, also 0531 600 and connect with us on Instagram, X, and Facebook at Advo Publishing. Don't settle for less. Choose the best. Advocate Publishing Company, empowering young minds one textbook at a time. Thinking publishing, think Advocate Publishing.
Oh, Jose, and I made the Asamasio. Cannon Pano, Nasana, Mishiana, what me. A drain I didn't quano. Kingdom Gallic Peters. No, more benefit. Me benefit wine. Also, got told dear. Abrewa, the smile, our brand said, Mishuve. One antique crown our bread. No Kingdom Garlic Bitters and any capsules. Nanya, what ya brebia.
Kingdom Garlic Bitters and the capsules. Assembia you. A devil when I'm when I say. Send your name, my wife complain one personal. Kingdom Ginseng Power Capsules and tea. Say, see, I'm password.
Kingdom Ginseng Power Capsules. A many genius from Debefi, Abrebia. Obebia o de poor hauno. Edro bakupa wihiane tremendous capsules. Tremendous capsules. Yes, you ma uye obesima. Edno you benya bi obebia eton robia. Kingdom Heba. No challenger.
Stand up. Hello, Ghana. It's time to celebrate 50 years of sports excellence. The Sports Writers Association of Ghana, SWAG, will honor and celebrate Ghana's sporting excellence at the 50th SWAG Awards in Accra. Date, Saturday, November 15, 2025. Venue, Accra International Conference Center. Time, 6 p.m. Theme, Gold and Glory. A call for change in national orientation and investment in sport. Special guest of honor, His Excellency John Dramani Mahama, President of the Republic of Ghana. Guest of honor, Mr. Julius Deborah, Honorable Chief of Staff of the Republic of Ghana. In attendance, Mr. Gianni Mello, President, Association of International Sports Press, AIPS. The prestigious and longest running awards event in Ghana, the SWAG Awards, promises to be an unforgettable night of glamour, excitement, and celebration of Ghana's sporting achievement. Performing is Afro-pop and dancehall star Stoneboy. Come, let's celebrate our sports legends and honor the best to inspire the rest. For sponsorship, contact 050-701.
West Africa's soil yields global treasures. Cocoa, cashew, shea, and cotton. They power industries across the world. Yet for our region, the greatest value still slips away, exported raw, taking with it jobs, industries, and the promise of shared prosperity. The real question is no longer what we produce, but who captures the final reward. True prosperity lies in the value we add right here at home. That's why the 4th edition of the EBIT President's Roundtable will gather the architects of Africa's prosperity and Africa's transformation to answer one defining question: how do we finance the journey from the farm to the port? Join Dr. George Ejikum Donkor and some leading experts as EBIT leads a high-level dialogue to unlock financing, empower local industries, and turn West Africa's raw potential into industrial power. Be part of the conversation redefining our economic future. Live on Metro TV, DSTV Channel 277, and EBIT platforms on November 24, 2025 at 11 a.m. EBIT President's Roundtable 2025. From the farm to the port, financing the value chains of West Africa's cash crops. My name is Anita Erskine, and it will be an honor to host you.
Kwame and his uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, Mommy.
I'm the second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Troll from Kaswa, dear. Why wouldn't he be late? Obey you later.
Of course.
Star 712 hash, star 712 hash. You go be the luckiest. Go be from Georgia, be luckiest. From not the block, she be luckiest. Yeah, you go be lucky, luckiest. No matter why you're luckiest. Everybody go be the luckiest.
That's Kwame!
Send your God the apple boom. If you're poor, what's that? So would the coming of the Son of Man be. Is that his car?
Ha! Even now, your shadow the way designer.
I use my own mouth to reject him. Oh, this is my mouth. Look at that.
Kwame, my son. Now, tell me the truth. How did this all happen?
Oh, Mommy, simple deletion. Mr. Good Luck no me way.
Yeah, man. Easy kwa. Or dial star 712 hash.
The devil is a liar.
He picked his ticket and entered his lucky 5-digit number.
I'm his birthday.
Oh, how romantic.
And he followed the prompts. Yes. And then boom, confirmation test.
One quick, pick 5 numbers for me, okay? I'm feeling like 7.
Dial star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompt and let destiny handle the
You see how they love you now?
Yo, do you have family permission? Before December, may release a motivational album. Patapa, my super.
This promotion is regulated by the NLA on the Caritas platform.
Oh, Jose, and I mean, the Can any pan, na sana, Mishiana, what de me? A drain I didn't quano, Kingdom Garlic Bitters. No, more benefiting. Me benefiting wine. Also, got told dear.
Abrewa, the smama, Abrente, Mishuve. One antique crown our bread. No Kingdom Garlic Bitters, and any capsules, Nanya, what ya brebia.
Kingdom Garlic Bitters, and the capsules. Assembly and a devil when I'm when I say, Senior Nami wife complain one personal. Kingdom Ginseng Power Capsules and tea. Say, see, I'm passway.
Kingdom Ginseng Power Capsules. Many genius from Debefi, Abrebia. Obebia o de poor hauno. Edroba Kupa Wihiane Tremendous Capsules. Tremendous Capsules. Yes, you ma your besima. Edro you when you be a ton robia. Kingdom Heba. No challenger.
West Africa's soil yields global treasures. Cocoa, cashew, shea, and cotton. They power industries across the world. Yet for our region, the greatest value still slips away, exported raw, taking with it jobs, industries, and the promise of shared prosperity. The real question is no longer what we produce, but who captures the final reward. True prosperity lies in the value we add right here at home. That's why the 4th edition of the EBIT President's Roundtable will gather the architects of Africa's prosperity and Africa's transformation to answer one defining question. How do we finance the journey from the farm to the port? Join Dr. George Ejekum Donkor and some leading experts as EBIT leads a high-level dialogue to unlock financing, empower local industries, and turn West Africa's raw potential into industrial power. Be part of the conversation redefining our economic future, live on Metro TV, DSTV Channel 277, and EBIT platforms on November 24, 2025 at 11 a.m. EBIT President's Roundtable 2025, from the farm to the port, financing the value chains of West Africa's cash crops. My name is Anita Erskine, and it will be an honor to host you.
Kwame and his uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, mommy.
I'm the second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Trotro from Kaswa, dear. Why wouldn't he be late? Or be late, of course.
Star 712 hash, star 712 hash. Yeah, you could be the luckiest. Coffee from Georgia be luckiest. From not the cause she be luckiest. Yeah, you could be luckiest. No matter why you're luckiest. Everybody go be that luckiest.
God, Kwamio!
Send your God the apple boom. If you put it so would the coming of the Son of Man be. Is that his car?
Ha! Even now, your shadow the way designer.
I use my own mouth to reject him. Oh, this is my mouth. Look at that.
Kwame, my son. Now, tell me the truth. How did this all happen?
Oh, mommy, simple direction. Mr. Goodluck no check me way.
Yeah,
man.
Easy car. Or dial star 712 hash. The devil is a liar. He picked his ticket and entered his lucky 5-digit number.
How much baby?
Oh, how romantic.
And he followed the prompt, yes. And then boom, confirmation test.
One quick, pick 5 numbers for me, okay? I'm feeling like service.
Dial star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompt and let destiny handle the
You see how they love you now?
Yo, do you have family permission? Before December, may release a motivational album. Patapa, my super.
This promotion is regulated by the NLA on the Caritas platform.
Vetting hasn't started in earnest. As you could see, the minority resorted to some tactics of obstruction. Let me put it that way.
Tactics of obstruction?
Obstruction, yes. They are obstructing the vetting process. Because, look, preliminary remarks are known to our rules. Right. And so if you claim that it's born out of practice, I mean, making preliminary comments before the vetting itself commences is something that is evolved over the period, through practice. Then you must understand that you must not abuse that particular privilege. It's a privilege,
it's about 1 hour 30 minutes.
It's not a right. Yeah. So how can you spend close to 1 hour 30 minutes making preliminary comments? And more so, you find that the preliminary comments are hinged on the integrity of justices who were duly, nominated and appointed to look into a petition, which has been dealt with and brought to finality. Now, that same issue is the subject of what? Numerous suits. Some of those suits are pending before the ECOWAS court. So why do you want to come and seize an opportunity like this and rehash arguments that you have pending before, those tribunals? I mean, it's a clear case of abuse. So I think that when we return from break, the minority leader and his team must understand that what we are expected to do is to test the suitability of His Lordship Justice Baffoe-Bonnie for the position of Chief Justice. That's all.
Well, is there
they
possibility?
must refrain from raising tangential issues and allow the process to flow freely. You see?
Will the majority have a meeting with them so that we can have smooth
Well,
flow
as
process?
for Parliament, of those engagements are permissible. But I think that, look, it is in the interest of our country, and of course for the sake of the minority's own image, to come back and ask legitimate questions. Test the suitability of Justice Baffoe-Bonnie. You can't hold the nation to ransom close to 2 hours. You're making preliminary statements. In most of the things is very clearly in breach of our rules.
How do we ensure that will not happen after the coffee break?
I think the speaker, or sorry, the chairman on this occasion would do what is right. I mean, and I'm sure when we return from break, the way would have to be paved for the vetting to start. Nobody is going to impede anybody's opportunity to ask questions. But the situation whereby, I mean, we're spending all the time making preliminary remarks is clearly unacceptable.
Well, Honorable, thank you very much.
Thank you. Thank you.
So we're looking forward to speak to more people on the said matter. I think... Doyo. So we're here with Honorable Comfort Kujo Doyo, that is the Adam Member of Parliament, who is also here. After the coffee break, we want to interact with some Member of Parliament to also take their remarks and also what is happening so far. I mean, have you taken your coffee? Have you taken your coffee?
Not really.
Why? Are you not taking coffee?
I'm okay. We just want this process to
like
go on smoothly and then...
Well, let us understand what happened in there.
Oh, it's the minority leader who is creating all this confusion. But whatever the situation, the Chief Justice nominee will go through, because we have the numbers and we are not relying on them, but they have to be part. So we are accommodating them, but we'll go through.
Others have raised the notion that the minority is not being allowed to, project their, thoughts on the matter.
What is the thought on the matter? The matter is there is a vacancy and the president have the right to fill that vacancy. And the president has nominated somebody. All Parliament need to do is to vet the person to go and occupy that space. So Parliament need to do their work. You cannot reject anybody here. All you need to do is vet the person here at the committee. Then you send it to the preliminary for debate. If after the debate and the majority of the members said no, but you can't reject here. You can raise objection, but all that they are doing, they are just doing politics.
They believe that the legal process has not been settled yet.
Which legal process again? They have gone through, or are they not in Ghana? They are in Ghana. And we have a lot of legal people who have seen that everything is done orderly. So what legal process are they? They are just doing politics. They are just doing politics. At times, they are micro minority and they want to claim a mighty minority. Even when we were 137, we didn't claim mighty minority. We want to claim mighty minority, which is not rare. But they want to use debate and other things to show Ghanaians that we are really mighty minority. Whatever they want to do, and Akama will say EMFA.
EMFA. Honorable, before you go, talk to us. Surely affirmation will happen. The acting Chief Justice will be vetted.
Yes. He will be vetted. They will bring the committee report and Parliament will approve it. So they are just maddening the waters. But Chief Justice will be vetted, committee report will be written, and they will bring it to the preliminary, and we will approve it.
When is it expected to end? I mean, from your projection, what is vetting expected to end?
Whatever the case today, vetting will end. Whatever the case today, vetting will end.
Thank you very much for having us. That is the Member of Parliament for Adan MP. We are live here on Good Afternoon Ghana. We're here. We still want to, we want to discuss matters with you. You're live on Metro News and also Good Afternoon Ghana. Talk to us. What are your takes so far after the first, is a segment or session?
It's annoying, right? It's annoying, it's irritating,
Oh, really?
When they are supposed to have been such an exercise, and somebody thinks that at every point in time, people must kneel down and beg him, people must kowtow to him. He is the only person who can speak and can scream and shout. It's very, very annoying.
Is he not making a valid point?
What valid point? What is that he's saying that he didn't say on the floor of the House? Why are we tolerating one person and giving one person all the space to misbehave like that? Is that the meaning of democracy? Is that what we are looking for? We are here to vet the Chief Justice. It's a serious business. And so let's focus on the germane issues, the challenges that confront the judiciary of our country. These are not the reason we are here today. We have not come from our house to come and sit here and look at one person doing these theatrics and this comedy. It's long overdue.
You think it's an obscure distraction to, delay it?
Deliberating. And guess what they are going to do? He wants the opportunity to look in the face of the nominee and everybody watching, say whatever he wants to say. When they finish, then they'll walk out. That is what they want to do.
Oh, that is expected.
That's the strategy that they are employing.
We'll walk out.
Let us tell them what we can tell. Let's tell them our peace of mind. We finish, we walk out. That is what they want to do. And who's going to allow them to do that? We have tolerated them for far too long. We are not going to continue again.
So will affirmation be done today? Surely the acting Chief Justice will be vetted the nominee?
Complete the process. We'll complete. They can't stop us.
Whether they walk out or not?
Whether they walk out or not, we'll continue the process and we'll complete it.
They have challenged the legal process, actually.
When they had their darling girl sitting there, they could achieve whatever they wanted. Now we are resetting Ghana. We are making things to be done according to the constitution of the country. No darling boy business any longer. So if the darling girl is gone and they are not happy with it, that is their own business.
It's rather unfortunate that an obstruction is being served so that delay will happen. But some have also argued that they have a valid point, that they need to ask the right questions so that we go through. So finally,
you are a journalist, you have been here. What valid question have been asked? All the things he has said, point to one that you can say a valid question that he has asked. It's not just a waste of time. It's not just drama, comedy of errors. What else has he done? Is that what you are looking for? Is that why we are here today? There are serious problems with our judiciary that we need to ask questions. They are very, very serious questions. That's why we are here. We are not here to joke. We are here for the Chief Justice to tell us what is coming to do when he take over office. That's what we are interested in. Not this, whether you are happy or not happy. Well, it's Ghana for one person. Are we governing Ghana based on somebody's personal interests? No. We have a constitution that is governing this country. And we have gone to the same process. Why? It was in office when they removed the former, what is the name, EC board. Didn't they use the same constitution? Didn't they go through the same process? So what is he talking about? What is he talking about? Is it not the same process that we use? A person was presented to the president forwarded same to the Council of State, they established a prima facie, a committee was set up, they did their work, and they came out their verdict. What has anybody done? Are we breaching a constitution? So why should one individual and a group of people think that they are superior to the rest of us? And what they think and believe must be the only thing that must be done in this country? Are they more Ghanaian than the rest of us? Are they more intelligent than the rest of us? Do they like this country more than the rest of us? We are not going to tolerate this. We have endured them for far too long. It's not going to continue.
Would a majority leader be in consultation with them to at least, tone things down so that we can finish the process and go?
To meet and have a middle way. We try to actually build some consensus. But when persuasion fails, they will do what we need to do. Ghanaians didn't vote for us to come and sit down here and fold our hands in our destiny and allow this micro minority to bully us and whatever they want to do. No. And nobody should take us for granted. Nobody should think that we are weak. We are not weak at all. We are very, very capable at making sure that the mandate that the Ghanaians are giving us, we will use that mandate to develop this country. We are not weak. We are not. If that is the thinking that, we are weak, we can keep quiet, we can allow them to do whatever they want to do, that is a joke. No. Ghanaians gave us the super majority because they want to see this country move in a different direction. And so anybody who will be an obstacle to that agenda will clear the person.
Well, thank you very much for having us. Anybody that will be on obscure destruction to whatever that will go on in Parliament or to whatever will go on here today will definitely be boycotted. We're speaking to a couple of the members of Parliament during coffee break. So what we are expecting to see is right after the coffee break, discussion will proceed, and then we will know where we are getting to. We're still looking around to see how we can engage other members of Parliament. Oh, we've seen Dominic Ayini here, which we would like to also discuss matters with. Right. So we want to discuss matters with him as to how things are going so far. So we have the Attorney General with us here, who is also, having interactions with some. You're live on Metro News, and good afternoon, Ghana. Talk to us. What do you make of what happened at the first session of the discussion in there?
I think it's highly regrettable because what the minority leader sought to do, first of all, I have to concede that the minority leader has a right by the practice of Parliament to make his preliminary, comments or express his views with respect to the nomination process or even the candidate. Okay, so having said that, I think what he sought to do was to bring the motion that was dismissed by Mr. Speaker to the committee through the back door, because in substance, what he was trying to say was exactly what was contained in their motion. And I think that that was regrettable. I think that the minority leader could have made a general statement that the minority opposes the process and that they are, as a result of their opposition, either not participating, okay, or that they have questions to be posed to the nominee with respect to why this should be happening at this point in time. That is the context within which I think he should have situated his comments. But the approach that he used was basically to bring the motion that was dismissed by Mr. Speaker back on to the agenda of Parliament through this committee. And that was, to me, regrettable. And it was a sheer waste of time for the entire committee. You can imagine that we spent about 2 hours just on his preliminary comments. And then also, it doesn't show respect to the nominee. Okay, there are 3 branches of government. Most of the time, I want to say that there are 3 co-equal branches of government. We cannot bring the potential head of one of the branches of government to sit here and wait for us for 2 hours just to debate amongst ourselves, whether or not his vetting should proceed. So I think that is highly regrettable. But that is all I can say for now.
So whatever that happens, the affirmation will be done. The acting Chief Justice will be affirmed.
It will come down to a vote. Right. And if it comes down to a vote, we are on the side of the president's nominee. And we have the numbers to do so. We are not abusing our majority. We are basically asserting, our right to confirm the nominee that has been put forward by His Excellency the President.
What happens if there is a walkout from Parliament, from the minority side?
Well, we'll have to continue because the practice and convention of Parliament is that once a quorum has been formed, that quorum continues till the end. And so we have formed a quorum. In fact, the majority side alone has quorum to be able to conduct the business of the House. But given the fact that the minority has joined us, a quorum has been formed, and if they do walk out, we will continue the business to its logical conclusion.
Well, thank you for having us. So we're speaking to Dominic Ayini, that is the Attorney General, who also gave his remarks regarding what is happening. So far, according to him, a quorum has been formed. And if a quorum has been formed, it doesn't matter whether the minority walks out of Parliament. Whatever that is supposed to happen today will surely happen. We're still leading agenda. We have the majority leader here, that is Mahama Yariga, which we want to also discuss matters with. He's having a short discussion with the Attorney General. We wanted to get him earlier on. Now you're still in coffee break. You're hoping that they resume around 20 to 30 minutes time, and then the process will still begin. Earlier on, we saw the acting Chief Justice, Baffoe-Bonnie, his Lordship Baffoe-Bonnie, who was also, I believe that he's also going to take his coffee. At least he has seated for long. Preliminary remarks has been going on. Issues has been discussed. For over 1 hour, 30 minutes to 2 hours, it has been discussion of legal procedures and all that. Like the Attorney General said, a lot will happen today. Whatever it is, affirmation will be done. Metro News will still bring you up to speed updates as to what is going on so far.
The rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Let me, Chairman, let me respond to him. There might.
You see, I cannot go and be giving you the opportunity when the person who is speaking is in the process of responding to the issue.
Also, a very, should I say heated? A heated up.
Yes, Honourable Minority Leader, you have the floor.
The morning, or as of this morning. So, it's difficult to explain, but I mean, all of preliminary comments happening, and it's 2 hours already.
Well, I think the very first thing that threw everybody off was the use of the phrase disputed nominee. That's where we start from. And that is what, where Afenyomaking was stopped right there, with some objections coming in. Obviously, the majority leader not allowing the process to go on. Let's have a lawyer, Kojuga.
Yes, because so on this table now, you are the lawyer, you are the expert. So let's take your view on the happening so far.
I think that it's unfortunate that a very important occasion like this for the vetting, where we are actually supposed to get to know as a nation the competencies of the candidate, what his philosophy and ideology, and how he can also improve the judiciary when he takes the reign of the leadership of the judiciary. We have reduced it to politics, where the minority wants to have their say, and the majority would also want that they operate within the confines of the rules, the standing orders. It is not like they don't know the rules. I think the minority leader has been in parliament for almost getting to the 4th term, and he's well versed with the rules. But I think what is becoming the problem is the choice of language, choice of words. And I think that they know what is parliamentary language. And for me, the chairman on the occasion has been firm to always say that let's operate by the rules, let's operate by the principles, especially when you make a blanket statement about people who are supposed to have done one thing or the other and who are not before Parliament, that they can equally respond or say, you give, natural justice is give everybody, and when they are not there and you are making these allegations about them, I think this is how they have reduced Parliament to be. I just hope and believe that they, as members of Parliament, will learn from the recent, it was the same committee that was going to vet ministers who were nominated at the time, and we all saw what it generated into. This is how it began. This is how it began that led to some members of Parliament be suspended by the Speaker. And I think that we may not have learned very well from that, because this is how the argument, the debate started, and at the end of the day, we saw the fisticuffs by members of Parliament. It was a shame and was a blot on the career, blot on Parliament, and this should not repeat itself. So it was good that the chairman, seeing what was happening, had to call for a break.
Yes.
And for cool heads to prevail. And I'm sure that once they have gone for break, they should have the caucus and have some conference, and also have a roadmap as what they'll have to do. Yes, we all know, we can read in between the lines, the minority will always have their say. You see, when you are not in government, there are things you can say and go scot-free. But whilst you are in government, governance is an octopus. It is something that you cannot have full grip over it. And if you want to do it, the minority has nothing to lose. It is you, government, who wants your programs and policies to run. And so we should not fall into the trap.
See a quote from Bernard Ahiafo Esquire, Member of Parliament, 6 minutes ago. Yes, 6 minutes ago. He says, never, in line with exactly what you're saying, never honor a fight on your father's farm when you know so well that it's your father's crop that will be destroyed. 6 minutes ago.
Yeah. So it is government that has business to do. It is government that wants the reset agenda to go on. So it doesn't matter what the minority wants to say or do. They always have an opportunity, even if they say it here and it's not captured as in the Hansard, because Parliament is an institution of record. And you don't want that they can always go for a press conference. So, like what the proverb is just said, it's apt. In my personal view, I don't think that they should leave them. Whatever they want to do, posterity will judge. Everybody will read in between the lines. But if you want to, it's not always because you are right, you want to insist, or somebody is wrong, you know he's wrong, and you insist that you want your pound of flesh. I don't think that's well. What they are doing is that they should just move.
For what the order states about statements. I'm not sure if I can. So I saw Order 94. It says time for statements. I don't know if it applies to only the plenary or applies to plenary and the committee. But this is what it says, that the time for statements shall ordinarily not exceed 1 hour, except that the speaker may permit statements and comments outside the prescribed period in exceptional cases. No. If this applies to the committee, the comments in the statements.
No, statements normally made at the plenary of the session Parliament. Now, this what has been evolved. What has evolved is that
no, what I want to
as a committee,
if
you want to see
applies
if statements applies at the committee level when they are doing vetting. And I said no. You see, what has evolved was that we have both the minority leader and the majority leader. Minority leader is the ranking for the appointment committee. The majority can always come anytime, although he might not be a member of that committee. But because they belong to leadership, they are given that privilege.
Okay.
So the ranking is given opportunity to make a welcome address.
Yes.
Majority would have to respond as a welcome address. So this is evolved by practice. That's why you can see.
The reason I asked this is there was a one, I think during the park committee, there was a minister, I can't readily recall, who appeared and a question was posed to him. And he made a plenary comment that that question has been answered at plenary already, which meant that he's not supposed to repeat it at committee level.
Exactly.
But for the purpose of what's going on, he will repeat it. So I knew that some of the rules, or I got to know that some of the rules applies at plenary and
the committee level. Yes. So that's why when the chairman of the committee said that we are not going to use the vetting committee, appointment committee, as a court of appeal to review what the speaker has already ruled on. Right. So I think because it's by practice that they have evolved this welcome address and the response, just to let members of the committee know that this is what we are coming to do.
Yes.
Yeah, we have to look at the competencies, we have to look at his conduct, whether he's fit for purpose or the person is not fit for purpose. A majority, that sets the stage for the vetting to comment. That's why the majority leader was asking they should point a rule that gives him that right that he always has to make a comment, that he cannot take that comment to become like press conferences. And that's why Anodom Pre also replied that yes, there might not be a rule, a standing order, but it evolves out of practices, convention of parliamentary. They are the master of their own procedure. So for me, it is important that the world is watching. You see, they should not reduce the August House into banting. There should always be a banter. You know, it doesn't augur well for us because I know the respect that people have for this August House when the Parliament, and we should not destroy our own.
Apayo said something that triggered him. He said the procedure also has its own political interest, and what he's saying represents his side of the House, his political interest.
He said it was a view of the minority.
The view of the minority. It has to be made. They must allow them to make it. Now, my question that came at the time was, at what point do we overlook the political interest and look at the national interest?
The political interest
do we ever draw a line, or it must go all the way through? Because then you would have to state the position of your partisan position at all costs, by all means, regardless what's happening. And the content of what he was delivering bordered on what had been done in the past about the former Chief Justice, and not the current one about to be vetted.
You see, when you really want, it's a view you are expressing. You can express your view, but you must be refined in your comment.
And be fair.
And be fair. I think some of the languages that you are becoming judgmental when the pending issues are inconclusive. That is where the majority has issues with, because that they are making blanket statements. You are not being factual. You are being inaccurate. And those are some of the things that the majority on this occasion has also said, I will not allow you to violate any inch of the rules. But you see, we should know the rules are made for us. They are handmaidens. They are not our masters. So we need to, that's why Parliament is allowed to adopt its own procedure, its own rules. Right, provided it is within the confines. So for me, just the recent past, we have done this to allow the military into the chamber. We have fought each other, broken, damaged state properties. Up to date, nobody has been set charge. All we heard was they were suspended. So who pays for the broken desk? Who paid for? Nobody. We have not answered, because it's not been very detrimental or penalized anybody. We are seeing the beginning of that. I just pray and hope that this vetting does not degenerate into such a thing, because I can see clearly that minority has taken a vested position. Majority has taken a vested, and that's where majority now, they are saying that no matter what happens, they will vet, they will conclude with the report. But I think that let's hasten slowly.
But I mean, if you don't want to, if you don't have interest in the vetting process, there's a problem that you just can't be a part of. You remember the famous Ablakwa resigning from the committee?
Yes, I remember. No, it's not about the, you see, the minority's view. It's not about what they are going to go through. Everybody can have a vested interest with their political leanings. What is happening now is that from day one, the way the former Chief Justice was removed, they have seen it in political lenses. Majority and the ruling government says that it is constitutional provisions that had laid down the procedure. We have just followed the procedure. Yes, others may say that my political party will do A, B, C, and D, right? Does that fall within the constitutional position that it dovetails into it? And they have done the same thing, and it is constitutional, right? Whether it was political, it was not political, it dovetails into the constitutional. The same process you have also used. And for them, they don't see it as a constitutional, they see it as it was purely a political orchestration. And they have gone to court, several, they've gone to all. And at the end of the day, Chief Justice has gone, the law has spoken. They have seen the law. If they had it in discretion, what they have done is within the law. Is it acceptable? Is that what the law says? And the law says that when you have been removed, there cannot be a vacuum.
Yes.
And that's where the speaker even says that if the argument they are making, that provided she has filed, the former Chief Justice has filed some processes in court. So are you saying that because processes has been filed, we should not go through the process, there should be vacuum? Then it means that anybody, any litigant, yes, any litigant can go to court and file a process and say, I don't want you to do this.
No, but the point I'm making is that there's no vacuum now because Baffoe-Bonnie is acting.
Yeah, he's acting. And you can't stop the government. You see, when it's a public institution, they are mandated constitutionally. The law mandates them to exercise some right. You cannot say that because I have not exercised my right, that of your right should stop. You cannot go on. And this is a constitutional duty that has been imposed on the president, that you nominate, you send it to Parliament, Council of State looks into it, the person is vetted. If Parliament agrees, then he's approved and he goes to his office. And I think there's a constitutional process that they are going through. I am very disappointed in what I saw this morning.
But did you anticipate it?
No.
There was a release from the NPP.
Ask me if I anticipated.
Did you anticipate it as well?
Yes.
No, what
I mean, to the extent that we are seeing currently.
I have anticipated worse.
To the extent that we are seeing. Did you?
Yes.
Well,
the reason I'm saying I anticipated worse is that I think when it started, I'm sure it was on the minds of a lot of the majority members that there was going to be something of this nature. But it has been managed to the extent that they've been able to control just at communication level by throwing banter at each other.
Yeah.
I mean, I said something, you said that was not possible. I'm not going to say it on the air. But it's something that I've anticipated that it might even be worse, except that we've seen the management of it. It's just been talk and talk and talk, which is good. And we hope that they have done that consensus and will settle so we can move on with the business of the day. Yes.
No, for me, what I anticipated was that they wanted to make a statement. After the statement, and they boycott the vetting. So that what they want to do is to write for a history that on this person's vetting,
you know, he made
we have not been part. We have not been part. We took a position
politically and
so that sometimes you don't give that legitimacy to the process. That's what I know they may want to do. But whilst the minority leader said they would never boycott, they will be part of it, I knew that they had their own questions, their own strategy as to how the vetting will be done. Right? And I'm looking at it that all they want to do is to frustrate the process. To frustrate him, and maybe any allegations that have been brought there will be this mudslinging, which at the end of the day will be something that will follow you through the career till you leave. Yeah, that's what I was anticipating.
But beyond making a statement, that's why I asked earlier on. Well, I'm sure there was some level of anticipation of an action by the minority. But to what extent? To the extent of making a statement to the extent of establishing their position, because I'm seeing a statement from the party, not the minority in parliament, but from the party at 11:47. That's when the release came. They did it today anyway, but I mean from the places I'm seeing it around 11 thereabout, when the acting Chief Justice had taken his seat already to begin the vetting. And so it presupposes that there probably was a plan in place, but to the extent of maybe a boycott, to the extent of this level of banter, to the extent of we are going to frustrate the process so that it doesn't happen at all, to the extent of the fact that the majority will now say, you can have your say, but we will have our way. I mean, to what extent were we to expect or anticipate something of this sort?
I don't think the majority, lawyer, what would you say? Because I don't think it was even the majority that made that statement. It was Hassan Tampuli that said the minority will definitely have its say, and the majority, you can have your way.
I think that has always been one of the maxims when you come to parliament.
Of parliament,
that you can always, yes, if we belong to majority, we would take a decision, we will have our say because of the numbers. So you can say everything, but the decision, when it comes to voting and the rest, we will carry the day. I think the majority also may have knowledge of some of the strategies that the minority may be trying to adopt, to put together. You know, Parliament is like, more or less, they have a mole in all of their committees. You know, this minority may have somebody within the minority who gives them information, and the same that majority may have somebody. That is why they have the creeps.
Yeah.
So that at the end of the day, they creep you in line, right?
Yes.
And when they get to know what is going on, so they always have the strategy and the grapevine information that they get, that they prepare for. That's why when they see the situation is so critical, the whip will have to marshal all effort. We saw people who they were sick. They had to bring them to parliament, the presence of parliament, in anticipation that if there was going to be voting, people who had traveled, that they have to cut short their travel and come back. You know, so it tells you when it's going, they may not get clearly what the strategy is, but when they are getting there, they know actually what the plans are. But for this, I think that the parliament should be able, they should remember what has just happened recently, which has embarrassed this nation, that we should not repeat such. If we repeat such today, certainly repeat, I think that they will be writing their own records, history, that it will be a basis for one day somebody to intervene and say that Parliament has been unruly, right? And we cannot continue seeing our parliamentarians being unruly. Nobody prays that we should have such a thing. But people are becoming so disappointed in politicians. And the little they do.
I agree with that.
The little they do. They are losing their confidence in the democratic processes. And if the people are looking confidence democratic processes, what do you expect them? The other alternative is the military rule they want. And especially, if you compare the military rule that we saw when we were young and the military rules this day, if you look at the Burkina Faso, Mali, and the rest, Niger, there's progress. There is progress in those countries.
Yes.
You see things for yourself. So people will now clamor for such a thing. I don't think that is where we want to go. We don't want to retrogress. But whilst this is going on among politicians who are the elites, who are the creme de la creme in society, who has to lead for leadership to show it's happening within them, I think that we should not do something for somebody to one day come and show us our own report and say, on this basis, we think that we are dissolving you and we will rule you by iron fist.
Let me make one point very clear for viewers before Annie, you take over again. So somebody is asking, Frank from Kaswa, why is only lawyer Adawudu on your platform making biased statements against the minority leader? If the majority leader had allowed Afenyo to end, we wouldn't have been here. I don't know which.
Someone also says that, hello, you see, I understand that minority Afanyoma Kings cannot make a sentence or statement without using abusive language. Unless he frames his sentence with abusive language, he cannot reach a particular point. Otherwise, he cannot make a point, and we should understand that.
Yes. So let me make the point very clear that Lawyer Daudu honored our invitation. We extended an invitation to in fact, we anticipated the nature of this whole conversation and how the veteran would look. We didn't want this kind of comments to be coming in. So we had invited both people or lawyers who are affiliated to both parties. We understand that we'll be having Lawyer Ishaq Ibrahim, maybe on Zoom. So we have done a bit of it. We extended an invitation. And so Lawyer Adaudu, and I don't think that you are being fair to him with the kind of commentary that has been run so far, with the kind of analysis that's been run so far. As far as I am concerned, it's been legal. I mean, based on legal expertise so far. If there is anything that goes against what it should be, I'm sure we'll both disagree, if I can use that legally.
Let me just make it clear
but
I have a lot of friends
fair,
within the
I
NPP.
don't think it's even unfair on our part to even allow you to send such a message, because we have invited 2 lawyers. One decided to join us but has not been able to.
Yes.
And we understand that. But it's also an open platform. So anybody that makes a comment, a statement, and you find it unfair, you are also allowed to send your messages and read that. But do not attack. It's unfair. So, lawyer, yes.
Yeah.
Okay, so please go ahead. There are lots of messages coming in. Samuel Brian Bobby, I will read the message.
Yes, I think that I have a fair number of friends, very good friends across the divide, right? I've never, in my training and my public speech, been acidic or biased or insulting. No, it is not part of me. So I won't do anything to hurt anybody's feelings. But the truth must be spoken, and I will continue to speak the truth. I'll continue to speak and to be fair and just in my commentary.
Yes, sir. So Samuel Brian Boabin says, my Lord, the disputed Chief Justice nominee, and adds an emoji of laughter. Samuel, good afternoon to you. He continues to say, Osahin Afenyo Markin is doing the Lord's work. More power, Osahin. This one says, hello, my name is Nana Kwame. It's obvious the way some MPs who were interviewed by your reporter, and he was speaking so rudely, which in my view was unnecessary because a lot of young people are watching and learning from these parliamentarians we call honorable, needs to act as such, not to talk in camera using derogatory statement about a whole minority leader of parliament. Having said that, I wish being a leader comes with being measured in your outbursts, especially when you are conducting government business. So some MPs need to look at the words they say to or about their leaders in camera. They are all our leaders, and one day some of these young people will be abusive and returned it to them, and I don't feel they will be happy with that. Thank you. So Nana Kwame Amponsa sent in that one. Nana Kwame didn't tell us where you are texting from. So as I said, we are still making sure we'll get Honorable or Council Ishaq Ibrahim to join the conversation via Zoom. Till we get him, we have done a bit as producers. So we'll continue with the show, and lots of, please, you are not allowed to call. You are not allowed to call. You can only engage us via WhatsApp, and we'll be happy to read them. Good afternoon. You're doing a great job. Please, if Honorable Afenyo Markin is raising the unconstitutionality of the vetting of his lordship, then let him be reminded He has a pending case of slapping a police officer, which police investigation has confirmed same. He has no right to be there. Kumi, please tell us where you are texting from. If you are sending us a message, we'll be happy to read and include where you are texting from. So, Nana Kwame, you have just told us you are texting from Kumasi Mampong in Kufiase. I think the Honorable Minority Leader should be allowed to make his opinion in our democratic system. We can't hold his throat and ask why he's coughing or gasping for air. He should be allowed. By Dr. Baraka Amasaman sent in that one. Dr. Baraka from Amasaman sent in that one. Breman, I am Hayford Kumi from Breman Esikuma in the Central Region. Okay, so Hayford, I've read your message already. Someone says, good afternoon, Metro TV. Interesting discussion. Thanks for bringing us the live broadcast. It's just disappointing seeing adults misbehaving on television. Eche Doche texting from Accra. Eche, thank you very much for texting. You said you are disappointed seeing adults exchange these kinds of words live on TV. Good afternoon. As a 19-year-old, I think all this starts from the removal of C.J. Gertrude to remove the head of the judiciary with accusations which lack gravity, makes the whole process suspicious and technically unfair. I'm sure you want to write. Secondly, I think this is all from the NDC government because of the comments they made when they were in opposition. I think politicians need to be very mindful of what they say when they are in opposition. Now the minority is labeling a constitutional process as a witch hunt because of their remarks. Joseph from Kaswa sent in that one. Joseph, that's your opinion. But as to whether you are 19 years old or not, we'll see whether we can be able to prove that. So again, please, you are not allowed to call, and you are only allowed to send in your WhatsApp messages. Please remember and take note that we are live on Metro TV Online. We are live on Facebook page Metro TV. We are also live on all our social media pages. So all of these updates that we are bringing you live on TV is also being brought to you by our social media handles. You can actually get the bits and pieces, the bites, the sounds, and the sites on our social media handles. He's texting you.
I'm giving you the permission. Tune off Metro TV for a moment.
So, Council will come back to you, but let me do one or two quick ones. Good afternoon. This is Salom from Tesano. It's unfortunate we as youth have very little to learn from people we voted for to make laws because they are more lawless than the ordinary street novice. In any case, may I know, is the former CJ was for Ghana or for the MPP? I'm sure if you are writing, if the former CJ was for Ghana or for the MPP. The minority leader can do better. What I've learned from him so far is verbal abuse and slaps. Don Jiro, I'm saying that please add where you are texting from so that we can actually be able to identify you. Carlos from Ododo says, you see, I understand that minority leader Afenyo Makin cannot, okay, I've read that already. Carlos, he said he cannot make a sentence or statement without using abusive language. Unless he frames a sentence with abusive language, he cannot reach a particular point. Otherwise, he cannot make a point, and we should understand that. So, Albert Yabua, or your nickname is Carlos from Ododo Diodio. You sent in that one. Please, from Ashaman Edmond, please, I have that one of majority side saying that they protect their own, which means majority side are always protecting their own. Edmond from Ashaman sent in that one. Hi, Afenyo. Hi, Afenyo should know his misbehavings will at the end send him to a tight corner soon. You still haven't told us your name and where you are texting from... Good afternoon, Kwesi. I'm highly disappointed in the management of Metro TV. How can you empanel only NDC members in your show? I used to know Metro TV as impartial and neutral, but now you have veered off standard. Shame on you people, especially Kwesi and your co-host. You know, I love reading messages like this, especially if it's an attack on either my person or the station, because it gives us the opportunity to explain. And I have said, and I'm going to repeat, that we as producers have done our maximum bit to invite all parties to the table this afternoon so that in anticipation, we didn't anticipate anything negative, but because we knew it would definitely take a political twist or dive, we invited both the, not members necessarily, but NPP-affiliated lawyers and NDC-affiliated lawyers. We honorably have the council lawyer Kojuga Adaudu seated in here, and we thought that even after the initial point when the vetting began, he was going to maybe go on break, but he stayed through with us, and so you cannot please attack him. As we move on, we are sure and hopeful that we would have the affiliated lawyer of the NPP also join us. Oliver Bamba says, from Salaga says, the vetting process for the contested Chief Justice will go on. The minority will surely express their concerns, but in the end, the majority will determine the outcome. So for all of these comments that we are having, you can go on our social media platforms as well. Put up your comments. If we find them, we'll try as much as possible to read them for you. Let's engage. Let's engage. We are bringing you snippets of the things that are happening. We had an interview with the Attorney General exclusively, only by Metro TV, of what he thinks of the process which is currently ongoing, and we'll put up that up on social media for you pretty shortly. Engage us. Put up your comments. Would be happy to reply. Good afternoon, Kwesi. Lawyer Dawoodi is comfortably and critically criticizing the minority because he's an NDC supporter. He should at least be able to point out flaws of the majority as well. From the very beginning, there was clear evidence of a deliberate plan to remove Madam Tokonu as Chief Justice. Hence, I'm not surprised by this new development. Clearly, the CJ's tenure of office is likely to be coterminous to that of the president-elect of the day, and that's a very dangerous precedent to happen to our democracy as a country. MD, Seshi, we also sent in that one. MD means McLean Desmond. McLean, I don't know why you have changed your name now to MD. Afenyo Makin is displaying industrial misbehavior. What do you mean by industrial misbehavior? Ghana in the parliament is not his property. Comrade Theo Magnussen sent in that one. Comrade, okay, thank you very much for sending in this message. It's the time for military intervention. All indications tell it louder. See Democrats non-conforming to their own agreed norms. See the wastage. Can we quantify what we've lost in this lost hours? I am Edu Bonsra from Abusko in Obuasi. The former CJ was unfairly removed, and the beneficiary was right before the appointments committee. I think the minority leader should be allowed to make his point because all meaningful Ghanaians know that Ghana judiciary is completely under attack and has become partisan under this government. It's very shameful that we have gotten to this far. From Kweku in Kolebu sent in that one. Samson in Amasaman. This is very interesting. Samson says, good afternoon, Kwesi and Nani. What is Mahama Yaraga's problem? He should allow the minority leader to say whatever he wants to say. And that's why I think it's interesting. And after he is done, I'm sure you want to write, he can come in and address whatever issue he wants to address and allow the process to go on. Who is the majority leader trying to protect or defend? Samson in Amasaman sent in that one. I'll pick this last one, then we can come back to the room for conversation. Lawyer Dawoodi is here, and our producer, Bright, please do make sure if we can get Ishaq Ibrahim to join, at least via Zoom, at least let people see him, even if for a minute, If you are not getting him, that would not be a big problem because we spoke to him early on. Good day, sir. Please, what we are witnessing is a shame. We voted for them to come and do a party bid and not the people they represent. It's unfortunate they're selling this type of characters as honorable. Sorry. What we are doing will make some crazy people jump in and stage a coup, which we don't want. Please, the MPP should calm down. My name is James in Accra. Lots of messages coming in, but I guess that, Danny, we should come to the studio a bit, and then we can go back online. But do remember that you can still engage us on our social media platforms. Go on to Metro TV and Metro TV Online for our news item. Engage us there. We are happy to come on there, have an interaction with you. We'll comment on the comments or we'll reply to some of the comments as you put them there. And if we get them, we'll try and read as well. So go on to Metro TV on social media, on Facebook now. Everything that you are watching now is also being captured there. You can watch us live. So tune in. There you get more than we are giving you on TV because the sights and sound, the other interviews that are happening are also posted there. Let's engage there. So we are back into the studio. People are attacking you that we brought you alone into the studio.
No, Kwesi.
Yes.
I've always come to a point that, like we said before then, I was saying that let me alone. I think that what minority leader wanted to say, the majority leader could have taken notes and respond to him appropriately when he was also going to make his introductory remarks. But I think that they have sat in Parliament and they have their own strategy, and have decided that maybe on this occasion we will not allow him to use invectives on any other persons, that it is becoming unparliamentary sometimes. So if they say we have not said anything, I don't think they were listening from the beginning. Yes. And the gentleman from Sefiri also, who is saying that the tenure of the Chief Justice is going to be the same as the President. No, it is not true. That's not the position of the law. The position of the law is that for every Supreme Court judge, that Supreme Court judge, your tenure ends at age 70. Your tenure ends at 70. So if Justice Baffoe-Bonnie is confirmed, that means that his tenure will end December 2026, right? There is no extension. For all that I've read and all I've seen in my practice, I've not seen any Chief Justice whose tenure of year has been extended. No of that. The President has mandatory 4 years that he goes back for the people to renew, and they have 2 terms. And His Excellency John Dramani Mahama has made it clear that he's not going to contest for a 3rd term. He won't do it. For him, whilst the Constitution has said it is 2 terms, his understanding is that you go for 2 terms. That is all he has said. He says the 2 terms. People, you see, there have been various interpretations. Interpretation will only come in when it is unambiguous. The Constitution says that you have 2 terms. Whether it's the literal meaning he's put or the purposeful meaning to that interpretation, the President has said, this will be the end of my 2nd term, and I'm no more going to contest. Even, I'm sure, people within the NDC as a party even believes that 2 terms should undergo interpretation. But, you don't just go there and say, I want interpretation in the Supreme Court. There are criteria before the court will come and say that you are putting different meaning on the same words. It's unambiguous. That is when they would interpret that. So the gentleman in Sefiri also, Supreme Court, when you're at High Court, from High Court to Supreme Court, we call them the Superior Court judges. High Court, you retire at age 65.
Yes.
Court of Appeal and Supreme Court, you retire at age 70. There is a reason why it's been done like that. And from my practice and from what I read, I've never seen any judge whose term of office was extended. That we can say because of politics, we are extending your... No, it's never happened.
Mm-hmm.
Right? And I know people who had even been appointed less than a year to the Supreme Court. It is because of the knowledge and the legacy they will leave. Example is Professor Kluje.
Yes.
Professor Kluje, very excellent lecturer, a jurist. He had all experiences. And this issue came up when President Kufuor appointed him to go to the Supreme Court. And I remember very well the former president, Akufo-Addo, at the time he was the Attorney General. And he said, even if Professor Kluje would spend even only a day or few months even on the bench, he believes that the legacy and the knowledge that he will bring to add up to our law will be excellent. And it has come to pass. One of the cases Professor Kluje did, it's Brown versus Oklika. One of the principles he has made in law, land law, is that customary law knows no writing when it comes to land matters. You know, now people will say, have you prepared your documents? Do you have an indenture over your land? In those days, nobody prepares documents to say about this land.
Yes.
It was just a matter of a gift.
Yes.
Or we know this land belongs to Annie. We live close. The children, the family is for this family. So you cannot now come and say that because I have a document purporting to take Annie's land, it belongs to you. If Annie can prove that her generations have been on that land, it is for them, you cannot bring a document. So that has been the principle now that cuts across. The customary law knows no writing. Right.
Well, we're hoping to get some of the MPs from the other side. Those of you who are attacking lawyer Victor Kojoga, please be fair.
In fact, there's an interesting one from
be
his
fair,
friend.
because we have actually spoken with lawyer Antiedu already.
Yes,
it's just speaking on the minds of lawyers.
Yes.
He's not here as a party person. He's just here as a professional.
Yes, so there is an interesting one from your friend Samuel Brian Bobby. He says, you see, Lawyer Daudu is a fine gentleman. Even if he's among the NDC lawyers who pressured President Mahama to remove Justice Tokonu, let him take note. The future MPP government will remove the Chief Justice appointed after my Lord, the disputed Justice nominee Baffoe-Bonnie.
There is a case. There's a case that lies within. There's a case that lies within the quarters of the NPP. It's a high-profile case. I'm sure Lawyer Daudu doesn't even know I know. He's a lawyer to that case. I'm not going to mention the case.
Okay.
And you create problems.
I'm not creating problems.
You create problems.
I'm not creating problems. It's his profession. People should just be you know, let's see things lightly. Don't be too deep about things. It's just...
You know, let me make a confession. I know Chief Justice Gertrude Isabasaki very, very well. Right? She's been one of my mentors in practice. When we started practice, she had also just come to the High Court. We have good relations, right? This is a matter, if you find me in all this matter, I only speak what the law says. I don't take personal issues, take sides as to what had happened, right? So I won't come and pigeonhole people and say no. All we are saying was the process.
Yeah.
Was it constitutional? Was it legal? Or it was political? How do you see it? Depending on where everybody stands, sees it. But from my learning and my training, I see it that it has been constitutional process. And you see, we should not forget that when we look at our constitution, it is legal and political issues that has been mixed, that has been put together as a constitution. There are political issues in there, there are legal issues that has set the whole thing. So this is how it is, and that's how we as a country have decided that we should be guided. There's nothing you find within the law, you may not find some political underpinnings in it. There might be results as from consequences that we had suffered, right, from our previous doings, our parents, our ancestors. There was some example I wanted to give to you why we now have, I think that in the 1969 Constitution, we used to have something called ombudsman.
Yes, ombudsman.
The ombudsman
Yes.
is just the same thing that has been refined and polished to become Shraj,
Okay.
right? The Shraj that we have now. So it is, there was something typical I wanted to give to you, that those human rights issues that had happened in 1969 and the rest, that's why in the following year, we have seen that there has been, let me give you a typical example about why we practice the hybrid now. You know, 69, we practice the parliamentary system of governance, that the prime minister was the head of government and the president was ceremonial, that we shifted. It was, and those days you could take your minister. But now, because of 1979 experience we had with Liman, where his own people, parliament even rejected the budget. That is why 1992, we now have that coordination,
Yes.
that the number of ministers must come from parliament. So that if it is seen that it is, the person is one of your own, there could be that collaboration. We have experienced that one too. We are seeing that it is not helping us. It's become like scratch your back, scratch your back. We are all in parliament.
No, I think it's just a matter of it's outliving its purposeful.
That's exactly. So now, I'm sure that if there's something we need to do, we will also have to look at it. So that's how things are.
So let's look at the content itself of Apayamakin's statement. And first of all, let's look at his statement of the political position. Mayarga has taken a different twist that we don't know him of that. That's because of how calm sometimes he can be. But I think he also read in between the lines on the political path Apayam was taking and decided that he was going to meet him boot for boot. Unless I am wrong. Just let me know about it. Because the way, like they said, you're marking every sentence of ours. Why?
Yeah, you see, I think that it is some of the choice of language within.
Yes.
You can always make your political point. You can say things. But then I think as he's saying, and the things he's saying, you know, for some time, just from the beginning of Parliament, there have been a number of people who are concerned about how the minority leader puts his words or his question. Are you getting it? As if he's in a fight with somebody. Sometimes some of the words you feel is insulting and others. Maybe that may be his style. But a lot of people are not comfortable with that style. I'm sure he's to attack.
He said, I'm not here to attack anyone.
That's the minority leader.
Yes.
Yes. I'm saying that he's making a point that this is our view.
Yes.
This is our view as minority. We will hold on to this view. Nothing will change our mind.
Is that,
right.
Is that an extremist position? They have taken an entrenched position.
No.
But even in my case, it is the choice of words.
It is the choice of words.
What constitutes an attack? To describe a person innocently being brought before a committee to be vetted for a particular position and describe him as a disputed nominee what wrong did that person commit to receive that kind of attack? I mean, I consider that as an attack.
Well, maybe the dispute is from them as minority.
No, yeah,
so based
the way
on that,
he described
it, which
at
is
first when they
the
said
person
it,
of,
yes,
the acting chief justice.
No, when he came back,
yes,
and after Ayariga raised the objection, and he came, he said because of the process they had gone through all.
Yes,
that is the dispute he was referring to.
Yes,
that the Chief Justice removal, that's when he brought in Justice Poama, that his committee, they think that it is travesty of justice.
But lawyer, Parliament
right?
is a house of records.
Exactly. And that's why I'm saying that, this had been issues that were raised in the motion.
Yes.
That motion that has been struck down by the Speaker. And they are saying that most of the things you are saying is being rehashed. Which for us, we think that what Speaker has ruled on, you are bringing it back for us to be a question.
So it should have ended with the Speaker's ruling.
That's exactly. Week. I think that is the point the majority leader they are trying to make, and that's why the chairman is saying that let's operate within the rules, the principles. Yeah.
Let me come back to some of the text messages that we have. And I've said that quickly go on to the Metro socials for me. Metro TV news page on Facebook, and I will engage you there, and you will engage you there as well. You can go to Metro TV online to see the news updates as they unfold, as they are happening in Parliament House today. And it's not only in Parliament House, every other thing that's happening in the country today, we are bringing them to you live and colored on our social media feeds. Metro TV Online is also bringing you the news update. So stick and stay with us both on air and online. Good afternoon.
I wanted to read this.
Please go ahead.
Gideon from BBNE said that it's evident that the Ghanaian judiciary is on its knees under the NDC, and John Mahamad's administration, listening to Honorable Fred Agbanyo, provides a clear understanding of how the majority has used the numerical strength in Parliament to bully the NPP. So their actions reflect a worrying pattern. You think you can bully Afenyo Making? They actually reflect a worrying pattern of empowering the minority rather than engaging in a fair and balanced governance. Frankly, it is no longer surprising, especially considering the bills have been passed in the middle of the night, bypassing transparency and proper scrutiny, you say. We're told that they're actually back, the committee is back.
Well, let's see. If they are back,
are they?
We would have to, okay, they are seated. Okay. Or these are old bites. These are.
No, this is live.
Okay, so if it is live, then continue sending in your messages.
Okay.
We'll try and read everything that you send. Plus, engage us on social media. So whilst they are live, we'll be engaging you on social media and Metro TV online for the news update. So let's get in and see how it's unfolding now.
Politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives, or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution, and he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives, saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear. that any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair.
Honorable Minority Leader.
I'm a member.
Please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader, you have the floor.
Seal that to me. But seal that to me.
Mr. Chairman, some of my... Yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure, but
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised, yes, Honorable Nimedu, let me hear you.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray, after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on me, a member of this house. Every committee meeting, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise a question about what I heard other people say that, well, there had been issues, nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now, we have been here all day. The nominee had not even spoken a word. This objection, that objection, and
Honorable
and yet we are getting nowhere.
You raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
It's not in response? Wow. Wow. Chairman, thank you. Your response to the issue that oh, very well. Chairman, nowhere in my submission did I impugn improper motives. Or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that.
Leader,
no, Chair, he was just talking.
Just address the chair.
No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the rank is doing is not right. You were given 5 minutes. We spent 15 minutes.
You don't have the floor. Honorable Dapamako, you don't have the floor. Honorable Roxanne Nelson Dapamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG requested, applied to the court for leave to file out of time. It is a statement of fact. We are not saying anything apart from what is in the public domain. So, Mr. Chairman, the majority leader must be restrained. All the confusion is being caused by him. All the confusion, I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader.
Chairman.
With all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman.
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where they'll come, force you, speak, put on a mic, then you will say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very loud and clear. If you disagree with it, you know what to do. Will you proceed?
Don't worry. Don't worry. We are all aware of what this whole thing is leading to. So no problem. Chairman, we, the minority, hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokono. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither Parliament's ally in political projects. It is a guardian of our Constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
Woman, comport yourself.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give rights to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much indeed.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Should I respond?
The report is not ready to be voted for. We are not at a stage of approval. So your conclusion is very preemptive.
Chairman, let me
Chairman
would respect. Chairman would
this is not what I want you to respond to.
No, Chairman,
so
but
I don't want your
Chairman,
response on this.
To the extent that you've raised it, I just need to.
Honorable Chairman, Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected. We don't need to vet
agreed on your position.
We rejected, and we
agreed on your position. Yes. Yeah. When it is time for voting, then you can vote against the nominee. Yes. So we thank you very much, and we wish you a very good luck. Honourable members.
Why you wishing us a good luck?
Yes, sir. Yeah, okay. Yes. Honourable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions, and my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. Be calm and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Please, before I answer the question, may I be expected to, may I be allowed to read a brief, make a brief opening remarks?
Allowed, you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of June 2008. So 17 years plus, I've been a Supreme Court judge. Before the 11th of June, for 2 years, I was a Justice of the Court of Appeal. Before then, I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Korongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. As a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekende, 1 year in Sekende, and 4 years in Kejetia chambers in Kumasi, where I practiced with my friend, the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988 and I underwent 6 months military training, and I was posted to Sekende. That's where I met my wife. At the time I met my wife, he was also a Bob No rank person. She didn't have any rank, actually. A sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So
very interesting and controversial moment. We are told that the minority, which has just walked out of the vetting room, the appointments committee room, has begun a press conference. Let's see if we can get to our colleague, Dominic, to bring us up to speed what's happening and who is speaking. So let's get straight again back to Parliament.
I personally appended my signature to the motion that we put before the Speaker, and we got the notice, I think on Friday night or Saturday morning, that the Speaker did not, yes, on Thursday night, that the Speaker did not admit it. And between Friday and Monday, I don't know how fast we could be to file a process in court. So maybe we can consider that, or probably it is Osho's.
You consider he's going to be the Chief Justice of Ghana. You are leaving with your questions.
by virtue of living with your questions, aren't you denying the country that scrutiny that you have given you?
No, even that, I think there are members of parliament there that are going to, they have similar questions anyway. But the way things are going, yes, the way, I don't know when the majority took this decision that when a minority has a position, we don't have to air it. I don't know. Yes. And it's not right. Let's allow the process. Let's go through the process. All the questions that we need to ask, let us ask them. I mean, that is what civil societies demand, but it didn't work that way. So it's unfortunate.
Thank you.
We can't always win.
What's the next step?
We'll decide as a minority.
Thanks.
Well, so that's it. Questions being asked the minority members of parliament on whether they filed a motion or whether they filed anything in court to stop the vetting process. And you saw the responses from the minority side of parliament. But pretty soon we'll go back to the vetting room, the appointments committee room, where the acting Chief Justice was answering questions regarding how he met his wife and his early life. And it was an interesting story he was telling. Maybe a quick comment or one or two, then we can go back into.
Wife?
Oh yes, he was speaking on the fact that when he got enrolled into the prison
I missed
service.
that. I have to.
You have to look for it.
Rewind and go and listen to that.
And do the math on Facebook.
Yeah, exactly. but it just gone by is Honorable Anime Kwame Asante Akim Central MP representing the minority side of the House, who were explaining the position they're taking. So later we can actually listen and break it down. What the decision they've taken. But I think we should go. Do you want to make a point on their press conference or their brief? Your mic is off.
It's just to give reasons why they have decided not to be part of the vetting. And in that, the Speaker did not admit their motion in time, and they are not going to court to stop the process. Like we saw during their administration, any little thing that happens in Parliament, it goes to court. This time, we are not seeing it like that. So I'm sure that's what they want to inquire. Why is it that on this occasion, they've never gone to court for a quick resolution, as it used to be the precedent?
Well, so I think we can now go back in there to listen to.
I was going to say something, but again, I refuse to.
No, you see, it's interesting where he said that he met the wife, and at the time he met the wife had no rank, and he was a senior officer, and so it was a choice that he had to make between his work and his marriage. And his wife. And, I'm sure he made a choice believing that I have the right partner who will buy into my vision, my dream. And thank God today, they are all at the apex of their chosen career and profession. I think that
it's interesting. It's quite exciting to look at the two of them grow through their careers, and especially at a point where he had to sacrifice for the wife. You don't see these things happening.
And the wife is a lawyer too. She was my 1 year senior. Yes.
Wow.
Yeah, she's my 1 year senior.
Wow.
In the law school.
Okay.
So
we'll cross over to the vetting and take a listen to the nominee.
This man has integrity, and this man has what it takes to be a leader. and I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamagbo to ask questions. Honorable member, you are entitled to 3 questions. You may ask up to 3 questions.
Chairman, thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually would be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that's on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years, meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rawlings. Then I was promoted in 2000, and I was sworn in together with Secretary Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rawlings, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my Lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees.
Now, the argument is out there regarding the duration that presidential election challenges take. All the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you consider introducing?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of the, as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost, it was 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was no need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with the declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the EC, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that is granting that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be end before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the Lone Ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated...
Honorable member, I think you have asked your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dafamokpo, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovelace Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidia. I used to appear before her. So that was, and so, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrates. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. But they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with a career magistrate, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as your honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come out to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116 And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get people lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu.
Thank you.
You are entitled to 3 questions, strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's becoming very, very high. Higher as a result of the delays that are occasioned in the courts, so that even small, minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of, I was telling somebody that maybe the president even stole his the 24-hour idea, economy idea from the judicial service, because we have planned for some time now to introduce courts around the clock so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to restore the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Yarega, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have. No, we
want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left to, with time, maybe we will get to a 24-hour. I'm certain the president sold his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. Previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working.
assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Let me, Chairman.
With all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended. No. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are resident there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, resident there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidua, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, going from here to Koforidua is so easy, even though it is risky and inconvenient. It is still short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Secretary again. We do virtual hearing of appeals for Secretary. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidua. So even if the lawyers in the case are in Accra, they still have to go to Secretary to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Koforidua and Ho. We are trying to get to a situation where lawyers will not go from Koforidua Ho to Koforidua, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in, one of the parties could be in Koforidua, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my Lord is getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my Lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people, suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the things that we have fed it with. I think it is done elsewhere, so we can try it. But what actually goes into used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring the 6th person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper, and so I'll be very, very happy if somebody came and said, Daddy, I saw your picture somewhere. I mean, I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and two more cases are added. Then we have situations which I will refer to as, institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, and that was LN 140A of 1948 or 1950, 1960, 1954, LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for his security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clogged, what we can do is that we should be able to track. Now we have a monitoring team, which I'm going to reinforce, that should be able, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we could grant adjournments on the ground of somebody's wife, and because a lawyer says, my wife is being taken to the hospital. The judge asked us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. You have to come to court. And that is their system. But here, sometimes you have somebody coming to say, my father has died. 3 years later, he's asking for adjournment, and his father has died. 4 years later, the same father has died. How many fathers you have, you cannot really tell. So we see there's a human element to this. But we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice, and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice. Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean, unlike the, let's say, district court, the circuit court, and the high court, we sit in colleges, we sit in panels of more than one. So, and then we take decisions together. There is no, every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Wa. I went to the best secondary school in Ghana, Koronguduma Secondary School. Somebody went to a one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it is a girls' school. Achimamai Secondary School has now become a Fiakobi Girls' Secondary School. So he doesn't even know whether he's an old student or... So...
My Lord, he's still an old student. And the school is still in existence.
And then there is this Wa man who went to school at Koforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, I mean, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her ladyship Avrild, having to come together and then agree on something. Even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. It shows that we come, perhaps we come from different backgrounds. We will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this. And you should be able to discuss things formally and informally before things escalate. You should be able to do this. Even empaneling can create problems among you. When somebody feels that this man is not being empaneled, I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice, I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Dorothy Kulendi, Justice Puaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frumpong was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Hajaladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my Lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about. because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851, 851. As of today, they are 3,562, a variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, there are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the Justice for All back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he's on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. The main condition a judge looks at is, this man I'm releasing on bail, is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum, he's trying to run away already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant to bail It doesn't matter the offense that the person has committed. The judge may not grant bail, but even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And Honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, these old ladies, how when they said, in my time, the Catholic priest was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Kwankwanuase, playing drafts. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say the man stole only a bunch of plantains. Do you know what it means what the bunch of plantain means to my mother? It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Nsawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole or around the courts that they'll see me, because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced. But that one is in your bosom. It's a law that one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, you know, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted paroles may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you send to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal courts. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances?
Yes.
Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week. It is not, when we tried the Court of Appeal, 'Appeal' 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 we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible going to, having 5 judges stationed at Tamale to take care of the North. It is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have find ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi, and they will be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Ade. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected.
Thank you.
And to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.
brings you the hottest trending music videos, insightful interviews with your favorite celebrities, and some dance moves.
We also got your favorite celebrity talking about their deep, goofy, and interesting sides you and I can see on cameras and social media.
But hold up, this season we are bringing you a whole new different vibe. Spanking new videos, top 5 countdown, and the all-new segment dubbed MVC Experience, where we bring you close to music, fun, and more interesting vibes. Don't forget to follow us on our social media handles, MVC Official TV.
Can I ask you something?
Yes. Go on.
Can you stay away from Patrick?
Salut bébé. Comment tu vas?
Abego, I don't speak French. Hey, that boy had the audacity, the effrontery. Have you eaten?
Sometimes I wonder if really he's your son.
Mr. Gray is calling you.
Jesus.
Once your friends are busy learning, you are here watching series.
I don't want to destroy the love I have for you. Wait. Since when do you start having this affection for her? Oh, my God. See, your head like silver. You want Nora.
But how?
You my legs no more. What you more than my joke. Oh yeah.
Nora, where were you last night?
Daddy, dressed like this, of course.
So why did you call this morning?
Can you imagine? As that day, I think he was actually planning to have intimacy with me.
As usual, it's hurting. But waiting. You know, I cannot wait to be promoted, Mom. You know me, I get black belt, so nigga don't fuck with me. Hey. Nigga don't fuck with me. Bro, I go fit sound you for him. Hey.
I am not joking at all. See, protocol.
See, you sick of can whatever I act Mr. Gentleman, Mr. Gentleman, make no fool plus.
You can equally carry all the money in her room, and they will not touch a pinch of her hair.
What's going on between you and Pasolo?
You will find out when you get to the dining.
I have fallen for you down flat.
How long is it taking you to open the door?
Is that a condom? No, it's chocolates.
From finding your dream home to building a legacy for your family, the Homeowner Show has been your trusted guide.
How sure are you what you're getting is the right land? And it has to do with searches, land commission, checking social planning authority, checking everything to make sure that what you are buying is not a problem or a challenge-prone transaction.
The stress of even not owning a house and constantly coughing up to rent is a big issue.
Join me, Hannah Atiasi, and my distinguished panelists as we delve into exciting conversations. Season 3 of The Homeowner Show, every Saturday at 6 p.m., only on Metro TV. Don't just own a house, build a legacy for your family.
Metro TV, insightful and inspiring moments.
Can I ask you something?
Yes. Go on.
Can you stay away from Patrick?
Sally, baby. Want to go?
Abiku, I don't speak French. Hey, that boy had the audacity, the effrontery. Have you eaten?
Sometimes I wonder if really he's your son.
Mr. Gray is calling you.
Jesus. Once your friends are busy learning, you are here watching series.
I don't want to destroy the love I have for you. Wait.
Since when do you start having this affection for her? Oh, Patrick. See, your head like silver. You want Nora.
But how?
My legs no more.
Nora, where were you last night?
Daddy, dressed like this, of course. So why did you call this morning?
Can you imagine? As that day, I think he was actually planning to have intimacy with me.
As usual, it's hectic. But waiting. You know, I cannot wait to be promoted, Mom.
You know me, I get black belt, so nigga don't fuck with me. Hey. Nigga don't fuck with me. Bro,
I go fit sound you for him.
Hey. I am not joking at all. See, protocol.
See, you sick of can whatever I act Mr. Gentleman, make no fool plus.
You can equally carry all the money in her room and they will not touch a pinch of her hair.
What's going on between you and Pasolo?
You will find out when you get to the dining.
I have fallen for you down flat.
How long is it taking you to open the door?
Is that a condom? No, it's chocolates.
From finding your dream home.
You the hottest trending music videos, insightful interviews with your favorite celebrities and some dance moves.
We also got your favorite celebrity talking about their deep, goofy and interesting sides you and I can see on cameras and social media.
But hold up, this season we are bringing you a whole new different vibe. Spanking new videos, top 5 countdown, and the all-new segment dubbed MVC Experience, where we bring you close to music, fun, and more interesting vibes. Don't forget to follow us on our social media handles, MVC Official TV.
Metro TV, insightful and inspiring moments.
As usual, it's hectic. But waiting. You know, I cannot wait to be promoted, Mom.
You know me, I get black belt, so nigga don't fuck with me. Hey. Nigga don't fuck with me.
Bro, I go fit sound you for him.
Hey.
I am not joking at all. See, protocol.
See, you sick of can whatever I act Mr. Gentleman, make no fool plus.
You can equally carry all the money in her room and they will not touch a pinch of her hair.
What's going on between you and Pasolo?
You will find out when you get to the dining.
I have fallen for you down flat.
How long is it taking you to open the door?
Is that a condom? No, it's chocolates.
Welcome back from the vetting activity. Went on a break, and I think we're waiting for the team to resume, and then we will get back with the Magisi.
Exactly. It's been a long run for the day, especially for you, right? Yes. From the morning on the morning show, 7 a.m., and we are still here. But of course, this is for God and country. For you, the people that are watching us, we do this for you. The acting Chief Justice, His Lordship, Baffoe-Bonnie is before the vetting committee, and the news is that the minority who expressed their view in a preliminary comment by the minority leader, Honorable Afenyo Makin, have walked out of the proceedings as we speak. They did a brief press conference expressing the reason why they left, and the proceedings have gone on. The majority had said that we will still proceed and make sure that we vet and, if possible, eventually approve the nominee to become the Chief Justice. And so that's what we exactly are on. They are on recess currently, and we have been covering it. Lots of messages are also coming through.
So some of the issues that you just have to know, take note of, is the nominee admitting that, or, yeah, I think I would say, saying he's qualified, he's best qualified for the job, expressing how he has worked over the dispensations from one leader to the other, and the other from Kufuor through Rawlings all the way to Muhammad's time, being at the bench, how he even got married to his wife, how he had to resign to get married to his wife, who was at the precincts at the time, had no rank at the time. You know, that has been making headlines so far. But he's also saying that he is qualified for the position. He also says that he has integrity, and everything he has done also shows that he has integrity. So that is Baffoe-Bonnie saying so.
I think, but for the politicization of this entire process and the other perspectives, everything he's saying are things that we revere him for already. I mean, the things that he's been talking about are things everybody, especially those in the legal fraternity, will speak of him. I mean, the people that we come across, the people who know Baffoe-Bonnie, the people who have experienced him one way or the other, will sing the same song.
Well, I think across the political streams, nobody has really raised any issue regarding integrity.
For his person, yes.
So I guess we really don't, unless you have an issue you may want to raise, but so far his integrity is untouched and is not stained. We haven't gotten any issue to pin him down with it, and that is what has been going on. See, so the Appointments Committee of Parliament is vetting Justice Baffoe-Bonnie for the position of Chief Justice following the nominee by the President John Dramani Mahama, and also the exercise will also allow members of the committee to assess the nominee that has appeared before it. So that's about it. I guess it started with drama for almost more than an hour.
Close to 2 hours. Close to 2 hours.
It dragged and dragged and dragged, and then they went for recess for more than an hour again, came back, and that also delayed before the minority actually stepped aside. We're told that Hassan Ayaga Hakusi has joined us via Zoom for a conversation.
So let's see if he's on. Honorable, good afternoon. Thank you very much for joining us. I can see you, and I don't know if you can hear us loud and clear. So far.
Yes, good afternoon, and good afternoon for having me.
The processes have been going on. The minority has worked out, but they expressed their concern in a not a statement, but a submission by the minority leader, Afenyo Makin, before they walked out. And beyond that, the proceedings have gone on. Have you been watching?
Yes, I started following it when it started. From the beginning till now, I've been watching and listening. Mm-hmm. And I saw everything. I listened to everything.
I want to pick your mind on this. Yeah, hi, this is Annie.
Hey, Annie, how are you?
I'm fine, thank you. I hope you're doing well as well. Let's deal with the family matter. Is there a characteristics about Mahama Ayariga that Hassan is hidden that we don't know, that you may want to tell us as your brother?
I think that we all have the same blood. We believe in justice. Mahama is my younger brother, 2 years younger brother. I'm the eldest among the Ayarigas. Usman Ayariga is our last born. But the fact of the matter is that I want to agree with my brother in this matter, that from the beginning of the process, I listened to the interaction between the majority leader and the minority leader. And I must say, from my point of view, I realized where the minority was coming from. And I also realized where my brother Mahama Ayariga was going. Because this is a situation where both leaders are supposed to protect the interests of each house, each group. Mahama Ayariga was trying to protect his image as the majority leader and also as the leader of the business of the house, to make sure that minority leader would not come out with anything, just to say anything and walk away. Because from the point of his presentation, you realize that the minority leader was being a bit sarcastic in a way, trying to use certain unpalatable words to disorganize and discredit the whole vetting process, and then use that as an excuse just to walk away. You can walk away with even giving a very good presentation by saying that, look, you agree to disagree. In as much as you guys are aware that you don't believe in the new appointee to take over the leadership, and that you still think that there are processes in court and there are processes that have to be dealt with. You understand the law, but you do not want to participate in this process, so you decided that you want to walk away. That would have given us a very beautiful level of democracy, showing how intelligent and showing how, tolerant we are in this matter. But to discredit everything and use certain words just because you are looking for a way out, for me, it looks as if we're not serious in this matter, and the minority leader was a bit harsh in his presentation against a nominee who has nothing against you, who was just there, to fulfill his constitutional mandate, right? Okay, and then walking away. Why do we think that we have to adapt a system where when you are not satisfied and happy with the process, you just start walking away? What kind of leadership are we showing? What kind of parliament are we, trying to, tell the people? The people have voted you. You've come to parliament. Your duty is to be able to protect the interests of the people, your constituents. Represent them and make sure the right thing is done. But when we keep walking away, I don't know where we have learned this process of Ghanaian parliamentarians from both sides, always walking away and leaving the house matters to be in the hands of just one particular side. I think that going forward, our parliamentarians should learn something new and bring on board something that we all can be proud of and interested in. If you don't agree with me, it doesn't mean you should get up and walk away. You can agree to disagree, but yet stay and then make your point right and let Ghanaians hear that this is your view. Whether they like it or not, that is the view. But if you keep walking, now, what is going to happen is that the majority in parliament, led by Majority Leader Mahama Ayariga, have the right, they have the quorum. I think they have the percentage, 2/3. They can sit and do business without you. So then what is then the essence of the majority and the minority leader in parliament then? Then you become a useless minority leader, a minority section in parliament. And I don't think in this our level of democracy, as citizens, as Ghanaians, we want to show the world that we cannot bring in a new kind of political leadership and a new kind of parliamentary leadership. And that we should monitor. So I think I side with Mahama Yorga in his presentation that he will not allow him to an inch to say anything that is not accepted here. I think that was the best thing to do.
So what you saw him do, well, there are a number of people who also criticized that if he had allowed the minority to make a statement and maybe later they will counter and it becomes brief than the back and forth that happened.
Present your case, speak in a matured manner, and then walk away. I mean, that is not a big thing to say.
But, Honorable, what they have sought to do, I don't know if you agree, was to make their case and be heard. And they felt, the minority felt that this would be the best platform to have themselves heard. The other conversation is that it had been ruled on already by the Speaker of Parliament, but they still felt that this is a platform where they will be held, and then they walk away, not to boycott. And Fenyomakin had said that they are never going to boycott, and that they truly did not boycott, but came to make their case and then left.
Yes, that was his intention, but his choice of words were wrong. That's the whole process. His choice of words were wrong. His presentation was wrong. You just had 2 minutes or 5 minutes to put up a presentation as a minority leader. Present it like a leader of the minority side with decorum. Don't use certain words for a senior in the bar who you're going to face in the future. You're going to be having cases to send to the Chief Justice for address. You don't use certain words at that instant to discredit this whole process. And then your choice of words were all. I mean, let's be sincere. Who speaks like that? Let's be sincere. If I like the chairman said, the whole world was watching. The whole world was watching. What are we sending out? What kind of signal was the minority leader trying to send out there to the world? And what kind of signal was the majority leader trying to stop the minority leader from saying? The essence, the whole process was that majority leader was trying to say, don't use certain words. Your choice of words is my problem. And always and always, he comes back to the same problem. So I asked myself, was he there to just provoke people? I mean, let's be matured, my brother. Let's be matured in this system. We learn by the day, whether in parliament, in politics, in education, in life. Every day we learn something new. And we have to stop doing the narratives, the old ways of doing things, and move ahead and present parliament as one of the best institutions in our country. And let other people from different countries emulate the process of Ghanaian politics and politicians. That is the most important thing. Have we learned, or are we going backward? Are we using abusive words just to destroy the system, or can we use good words yet present our case?
So, in fact, I am struggling to put things in the proper perspective. We've had text messages from people who think that some of the words, or the words that we are describing as unpalatable from different perspectives, are okay, especially because they dispute the position of the acting Chief Justice to become the substantive Chief Justice currently. They think that they are a good voice to be heard, as in substantive members of Parliament. Now, Honorable Afenyomakin has stated clearly that the views being expressed were not views on his own volition, but views from the minority as kind of a statement or a submission from the minority. And so, is it because we find them as unpalatable, or because they are disputing and describing the acting Chief Justice to be vetted to become the Chief Justice as a disputed Chief Justice?
First of all, you don't expect to get good comments coming from the other side of the house. When the NDC and the MPP are having their banter, you don't expect members of the MPP to comment the NDC, or you don't also expect members of the NDC to comment the MPP. Definitely, you will have this banter whereby the group of the NDC, where the NDC members are basically supporting the comments, they're writing their comments for supporting the activities and the presentation of their leader, which is the minority leader. You, on the other side, you expect leaders from the NDC supporting the majority. I am sitting from a different angle, and I'm looking at the two. And I think that this is my opinion. Look, if somebody sends you a comment as a minority leader to tell the chairman he's stupid, will you just get up and write and say he's stupid? You won't do that. But that is his view. That is the view of the person who's sending you the comment. But you, as an intellectual, ought to present your case in a way that you are the one represented. Don't forget, future, like he said, history will judge them. History will judge him according to what he says, not according to the comments people are sending to him or whatever the house is asking him to say. This is he talking. He's the one talking. He's the one speaking. So history will have on record that he said it. History will not say that, oh, minority leader Africans was being forced to say certain words. Nobody thinks about that. As a leader, it is your duty, it is your utmost duty to be able to present a case that is decorum in a way. Don't expect people to tell you things for you to just come out raw and say exactly what they say. That is what makes you a leader. That is why you're a leader. You're a leader with a difference. You're a leader with common sense. If you listen very well, Mahama Yaraga gave him 1 point line. I don't know whether he saw it or he listened or he didn't realize it. He gave it back to him, 1 point. I don't know whether he realized that or not.
I did.
But I was laughing. I said, you see, yes. I said, you see, you've gotten one. Now you see how it is to feel sad and not happy when somebody says something unpalatable to you. Now, like the chairman said, the nominee has no power to defend himself. Or my former general secretary, Justice Puama. Justice Puama was my general secretary in the 20 years. He was the PNC former general secretary, if you care to know. He's a good gentleman. When they were talking about him, he kept quiet and he was smiling all the time. You understand? He cannot respond because you cannot put allegations to the person who cannot speak, defend himself. So as a minority leader, you ought to be careful. You're not just a common leader, you are the leader of the minority in parliament. What you say, what you do is recorded, and you will be held accountable for those kinds of comments. So do not listen to your section of some, you watch some of the MPP guys who were talking, some of Habib and others. I mean, you could realize that, I mean, there was nothing to say. The people were just reading the what do you call it, the quotations from the quotes from their this thing, and it was unnecessary. Why do you say that he has the right to present him? Who is stopping the minority leader from presenting his case? But we are saying your choice of where is wrong. So if you come and you want to make a comment, and instead of bringing out a comment, you say, oh, the chairman should allow him to present his view. Nobody stopped the minority leader from presenting his view. We say your view is welcome, but how you say it is our problem. So I am appealing to all of them, both minority and majority, that look, the world is watching you. The future leaders, the next generation are looking up to you, guys. They listen to what you say, what you do. Let us not be carried away by our stance of political division and not do the right thing. You are there to present yourself as a leader that has to speak to power, to truth, a leader that is credible, a leader that is authentic, a leader that tomorrow, when you are listening to yourself and watching, you hit your chest and be proud that you said the things as a leader, not to be listening to it again. If I ask Afenyo Markins to go back and watch the program again, I'm sure he will say that, look, if I had the opportunity, I wouldn't have said certain things. You remember the majority leader told him, if you want freedom of speech, go out there and assemble all the media men out there and ask them their view. He was just trying to tell him that they will tell you that you're wrong. You understand?
Yes,
That was
I
what
get
he was
it.
spelling out to the minority. I don't know whether he got it right or he didn't. But he was telling that if you assemble all the media guys who are here and go out back door and ask them whether what I said was right, they will tell you that, my friend, you're wrong. This country is governed by rules and regulations and wisdom.
Honorable Hassan Ayarga, Afenyomakin already indicated that the committee is back, so we may go back to them very soon. But he indicated that this also has political undertones and that he was representing the position of the minority and a political party as well. So no matter how much you read political meanings or undertones into it, he already stated that.
Yes, he stated that, but how he presented it was the problem.
Okay.
Okay, that's the point. The whole presentation was wrong. I mean, he had the opportunity to do that. But Annie, you represent Metro TV. Sometimes you people write comments under there. These are not from the office of the Metro TV. These are entirely your own comments. Don't you do that most time when people make some kind of derogative comments? You do that all the time. Am I right?
Yes, right.
So it's exactly the same. So, I mean, let's all be guided by the words, the choice of words, and then also educate the next generation how we should present our case, how this country should be governed. In fact, we are opposition political leaders, but we should respect that position and make ourselves more credible so that in the next election, leaders of Ghanaian citizens will vote for us. That is all.
All right. Hassan Yarga,
we're
grateful.
yourself better than. Thank you very much.
Right. We'll leave it here. Let's cross over to the committee as Baffoe-Bonnie is already taking his seat, already answering questions.
Right.
We'll be back.
Right.
Can I leave you now?
Yes, I think this will be their final session. Omoko recess and they will go and talk.
They have given the money out. They have bribed the judge. They have given, they are okay. So such people go about saying that, oh, the judges have taken their money. And once the judge has taken their money and they get their judgment, they are okay. But the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad notes among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in then we can tackle it. So if we sensitize people about ADR, mainstream court, and we sensitize people about ADR, people will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaints unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm not going to.
I want to find out, will you reinstate the electronic case assignment?
It's virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed, should be brought to my attention so that we fix, because most applications are time. Apart from four nominees of the presidency, we have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, a Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. But then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these three groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these three lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you will be a good material. So apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than 1 or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice, and so with this kind of nomination from these 3 people, how people can talk about political, I can't really understand. With the Chief Justice, the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the president has a say. And at least that is what our Constitution says. If Ghanaians believe that the Constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination. And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came back to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment in spite of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask the question.
I'm asking the question. I'm laying the my mic is... My Lord, I want to find out from you, do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me what I think the current arrangement is okay, or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, you as you rightly said, the nomination and appointment and everything is done by the President. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. That is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes?
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but Judicial Council, made up of members of the bar, members of the General's representative, these 37 out of 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how am I going, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. We only took our advice. So it is not as if, people's suspicions are going about that. You cannot go about trying to assuage people. You can't do that. People will still have their suspicions. One of the questions that I got was, people are saying, can I do anything about it?
Yes, Mr. Chairman. My second question, my lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 15, you as, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. The chairman, you become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talk about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways. It's only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year, all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then parliament. Whilst the lower bench have their salaries tied to normal civil service, civil servants. And worst of all, the JUSAG, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court. We are not known more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions. Because whilst we struggle, whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regions, regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
That will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules, so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process, because there are a number of suits pending challenging the removal of the previous Chief Justice. They're asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think, yes, it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment of to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction, or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Sito and other things came up and said that that was right. That was it. But the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, when President Mahama was declared, and it was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Kufuor from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and it would have been enforced by Article 1 and 2. The same thing would have happened in 2020, when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice, there's no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases.
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will it is, so I will pardon. But if a lawyer makes a statement like this, I will think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. Cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search, to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and then move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, word is sought, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and you fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything, and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he'll give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Ajimang. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you were part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes,
and
I mean...
The court was happy that they had finally resolved the matter. It was basically a land matter, but what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get Honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3, attempts to get justice?
Yes.
And if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review, that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level, which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku, so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the U.S., like South Africa has? What's your thinking in view of the discussions going on about amending and reviewing our Constitution?
Honorable Chair, this is a very interesting trajectory that this question is taking. People will, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 plus 9, that is 10, as our Constitution provides, and not go up, is dependent upon the jurisdiction of the court, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where cases can, civil cases, whatever, can go all the way to their Supreme Courts. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief tracing matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there's a criminal case, Ali Kasida, started in my village at Goso, and it ended up at the Supreme Court. We have cases, several cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to the Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, I mean, granted by the Constitution, that a person has a right to go all the way to the Supreme Court, people are prepared to, and now, see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You will find that about 35 of that number of years happened in the lower trial court. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submission of the parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where, finally, even where proceedings were supposed to be adopted, you will find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to ask it to arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement the writ, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay, for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2, just a view. My Lordship, Paul Baffoe-Bonnie, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair, I think I don't agree. I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training. We are doing substandard work that the products are not substandard. But that is not the case. We are also not overproducing. Actually, you see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together, from 18th century, Mensa Saba and all that, we're up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. a lot of them are migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even parties. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, you know, the law is such that the District Assembly law, the Local Government Act, expects every local government to have a legal department. And when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than 1 person. Every local assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or plying their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. The headmaster of my school, the best secondary school in Ghana, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which will be doing at the end of November, then when he retires, then he will pick his law, he'll go and do galamsey. No, not the galamsey. The lawyers understand legal galamsey.
Are you talking about galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So, my Honorable Chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further question?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's a federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America, of the U.S. That is, they are what you call a constitutional court. So, but Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We would not be able to work at all. The only thing that we have to, there are 2 things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. the way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court. By an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at the High Court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Director General Prison Service, Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedu Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family. We have Mary Kwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Anantahini. Forgive me if I don't pronounce it well. Typical Igbe boy pronouncing three names. Then we have Nana Dr. Abura Boatin Yinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have all students of Konongo Odumasi Secondary School. We have Felix Abuaji, Esquire. We have Justice Kusi Minka, Esquire. We have Koku Chiramantin, Esquire. We have Esuo Yao Benin. We have Captain Collins Fosu. We have Kwame JB. We have Kwame Ousu. Honorable members, we also have Marietta Ajewa Brew. The legal counsel to His Excellency the President of the Republic of Ghana. We have Benedict Bob Derry, Director of Prisons Operations. We also have Francis Omani Ado, Deputy Director General of Prisons in our midst. Honorable members, don't take offense in the event I do not mention your name. At the back, I have Nana Sangba Jafla II, Paramount Chief of Sampa Traditional Area, also representing His Royal Majesty Otumfo Osei-Tutu. We have Nana Baffoe-Bonnie Chichikra II, member of Asantehini's delegation. Then we have Berima Yao Koda Opon, Monwurahini of Achim Ebuakwa Traditional Area. Then we have Togbi Teprehodo the Fourth. I've eaten the okra, so I can pronounce this one very well. He is the Paramount Chief of Amfoga, the President of the Volta Regional House of Chiefs, President of the Volta Regional House of Chiefs, representatives from the National House of Chiefs, and is also a member of the Judicial Council. Then we have Nana Dr. Abura Boatin, the Chief of Nyanahini. I think I have announced. No, you haven't. I've done it. Now, back to the tall list containing the Supreme Court, Court of Appeal, and other judges. My lords and my ladies, I will urge the Hansa Department to capture every name that I have pronounced here, preface it with my lord or my ladyship, if I don't pronounce it. We have Gabriel Poma, Justice of the Supreme Court. We have Avril Lovelace Johnson, Justice of the Supreme Court. We have Richard Ajay Frimpong, Justice of the Supreme Court. We have SKA, my very good friend, Asedu, Justice of the Supreme Court. We have another good friend, Justice Tanko Amadou of the Supreme Court. We have Ernest Gaiu, Justice of the Supreme Court. We have Henry Kofi, Justice of the Supreme Court. We have Yao Asari, Justice of the Supreme Court. We have Justice Senyo Jamafe, Justice of the Supreme Court. We have Justice Bright Mensah, Justice of the Supreme Court. We have Justice Kweku Akabwefo, Supreme Court. We have Justice Dennis Ajay, Supreme Court. We have Justice Battles Kujo, Supreme Court. We have Justice Hafizata Amaliboba, Supreme Court. We have Justice Johnson Mbila, Supreme Court. No, member of the judiciary. Member of the judiciary. Yeah, Judicial Council. We have Samuel Afote, Judicial Council member. We have Ambassador Ekuya Sana Danso, Judicial Council member. Then I have announced Togbi Teprehodo already, but he's here again, Judicial Council member. We have Dennis Ejiram Fome, Judicial Council member. Now we have Georgina Mensah Dacha, Court of Appeal. We have Jennifer Abnadazi, Court of Appeal. We have Kofi Akrowia, Court of Appeal. We have Justice Pamela Kranti, Court of Appeal. We have Yao Onyamiye, Jacobo, Court of Appeal. We have Shilaminta, Court of Appeal. Gifty Dacham, Court of Appeal. Professor Olivia Anku Chede, Court of Appeal. Dr. Bampuru, Court of Appeal. Dr. Enes Owusu Dapa, Court of Appeal. Jerome Noble Nkrumah, Court of Appeal. Anthony Opon, Court of Appeal. Jafta Apau, Circuit Court. Gifty Ajay Ado, Court of Appeal. Olivia Oben Owusu, Court of Appeal. Alexander Osetutu, Court of Appeal, and he's my classmate. Cecilia Davis, Court of Appeal. Mariam Samu, Court of Appeal. Mariam A.G. Jawara, Court of Appeal. Sam Obong Diewu, Court of Appeal. Lydia Osei Mafu, Court of Appeal. Charles Wilson, Court of Appeal. Ms. Rosemary Gazy, Deputy Director, Communication, Judicial Service. We have Mr. J.R. Ampon Fosu, Director, Communication, Judicial Service. Honorable members, all the Supreme Court, Court of Appeal, other judges are all my friends. We have Justice Yoni Kulendis, Justice of the Supreme Court. He is also my very good friend. Honorable members, you are all welcome. On this note, I proceed to discharge the nominee after a successful vetting, and to add that, my Lord, acting Chief Justice nominee would surely hear from the committee. You are hereby discharged. Honourable members, I will ask the members of the committee to remain seated, and I was asked to add that in Parliament we don't clap, but we said here, here. Thank you all for coming.
Well, so it's been a very long day, right from 11:40 thereabout till 5 minutes past 7. A very long day, beginning with the plenary sessions where the minority leader, Honorable Afenyo Makin, had given his preliminary comments, and that took almost 2 hours. And then the walkout. Please take note that there was no boycott. It was a walkout. We are told that some people are talking about minority boycotting the vetting process of His Lordship, Baffoe-Bonnie. And that wasn't the case. It was a walkout. We've been covering this right from the morning before 11 a.m. up until now. A very extensive coverage from Metro Television. We'll be continuing with the news very soon, and I have my colleague Desmond here standing by to present us with the news. Desmond, what exactly are we going to see on the news tonight?
Well, of course, as you mentioned, it's been a very long day, and so we're going to have a lot with the news on the vetting today of Justice Paul Baffoe-Bonnie, and a lot of things that he says that we're going to be sharing with our viewers today. So really, that's a lot of it that will be coming in the news very soon.
And I'm excited about some of the bite sounds and sights that we had.
Right.
We saw our colleague Dominic from Parliament having a session with the Attorney General on his feelings and his reactions towards the proceedings as of the morning, as of their first recess session. I think that's exclusive to Metro TV, and you guys have done a yeoman's job.
Well, definitely, you know, that bit from Dominic inside Parliament, just, you know, on the lobby of where the vetting was happening, there are lots of interesting sound bites. He had that of Fred Agbenyo, who was talking about...
He was literally angry.
Yes, he was very livid that he said that, you know, they didn't leave their homes to come to the table to see such, in quotes, comedy that is coming from him. So he was literally livid about what happened earlier today with the minority in the vetting team. But I missed several other conversations that Dominic had with some of the persons in there. So it's quite interesting. I remember seeing one of the points where Justice Baffoe-Bonnie was talking about Tayi
the fear and the panic that if he had left him off the hook earlier than the 70 years given, if he came back, he was coming to attack. But Atai has gone in and gotten transformed.
He's been transformed, and he's a lot of things that bothers or hinges on some of the rulings and all of that. And also he says that, listen, he's not in here due to his affiliation to President Mahama, but he deserves to be
being the senior, gone through the process.
Definitely. So that's what he's been talking about today. Yeah.
Well, so I think that there is a lot to discuss, and subsequently we'll be digesting all the things that he said. One of the things for me, especially for you being a socialite, is the fact that there is a lesson for all of us young men, young women to learn from him, that he had to sacrifice a period of his career to accommodate his wife at the Ghana prisons and eventually become a lawyer. The wife is also a lawyer, and they have all gone through their careers very successfully. But we'll leave that to the discussions. Eventually, maybe entertainment will pick that up tomorrow, and then the rest of the discussions, Business Edge, other programs on Metro TV, we'll pick all of them up in the subsequent days. But for now, let's leave you to the news and enjoy what you have for us tonight.
Definitely. Thank you very much, Emmanuel Kwesi Efree. Now we're getting into the news for this evening. We're live on Facebook at Metro TV Ghana, DSTV channel 277, and also on the multi-TV digibox. My name is Desmond Okrekudan. So let's take a look at our headlines now. Coming up, Chief Justice nominee Paul Baffoe-Bonnie promises to champion a fair and transparent judicial system where justice is not influenced by status. We'll tell you more about that. And on that, also, minority caucus in Parliament earlier walked out on the veteran of Chief Justice nominee Justice Paul Baffoe-Bonnie by the Appointments Committee. We'll show you how that happened at the end of the day. And still on the veteran of the Chief Justice